Hold up, grab my soda, cause I told you I'm colder than hell. I ain't buying what you sell, it don't ring my bell. Unless it's got the smell, you know, like grape ape. We ain't talking vapes or the color of drapes. Or a gorilla in a cape is the good shit. Just one hit, you so lit, you fall into a bit, non-bit. What's fucking funny is you're a monkey, a high school flunky, hero and junkie, obliteration of the carnation with gross castration, skewed citations by your intimations. Get real, young man, there's only one stand. You can't stand a suntan, how you gonna live on the land? Obliteration of the carnation with gross castration in skewed citations by your intimations. I'm a truth in rotation, you're a cheap imitation. Dark said hums, 808s make the ground shake. Cold as the grave, every word's a land quake. You're a flicker in a cipher, I'm the flame that won't fade. Step into the night where the shadows are made. What's fucking funny is you're a monkey, a high school flunky, hero and junkie. I'm gonna click another hit of this good shit, and I'm already it, so take over, it's been non-bit.
Thank you for joining us at Personality Inventory Mockumentary Productions.
Pimp Edition. Welcome. Thanks for joining me today. I hope you're paying attention. If you paid attention to any video, please pay attention to this one. Because if you can say I've been correct without saying it, this does it. So please pay attention. First of all, we're going to look at the Sarbanes-Oxley Act. Let me get that up here. Sarbanes-Oxley Act. Go ahead and punch it into your search engine, and you're going to come up with several links. It's going to show you the LIIWEX link where it describes the Sarbanes-Oxley Act. And it says the Sarbanes-Oxley Act, SOX, is a federal act passed in 2002. If you remember Enron was not the one scamming. It was the federal government. It was the federal government employees that went to prison on this. And it was with bipartisan congressional support to improve auditing and public disclosure in response to several accounting scandals in the early 2000s. The act was named after the bill sponsors, Senator Paul Sarbanes and Representative Michael Oxley, and is also commonly referred to as SOX. You can find the statutory text at Public Law 107-204. So let's take a look at H.R. 3673, which is Public Law 107-204. Title 1, Public Company Accounting Oversight Board. Establishes the Public Company Accounting Oversight Board. So they didn't have an oversight board until this. And it oversees the audit of public companies that are subject to securities laws. And what we're talking about here, folks, is the courts. The courts are actually public companies, and they are, in fact, running securities. And you're going to hear in this video about the court registry investment system and about the birthright and all of this, the things that I've been researching for 10 years. You're going to hear about the 1099A, the 1099C. You're going to hear about the IRS Form 211, the Form 56, the Form 3949A, which I still have my copy here. When I filed my 3949A, as you'll hear in here, they were They were black shadowing it, or whatever you want to call it. They were hiding it. And that's what caused them. That's what triggered the court to file a protection order against me, because I was on it. I knew it was to do with the books. I knew there was something wrong. And I've been showing that from day one. And not only have I showed it in the courts, but I'm showing it in billing setups as well. Public companies, they're all running securities. They're all doing the same thing. They're all filling out those 1099-A, acquisition of abandoned properties. So pay attention. The next one, Sarbanes-Oxley Act of 2002, Public Law 107-24. And this, you'll notice, is Office of Administrative Law Judges. Okay? So they're all well aware of it. And it's a long document, but it's got all the information in there. Okay? And it's also in the U.S. Code, 15 U.S. Code, Chapter 98, Public Company Accounting Reform and Corporate Responsibility. Title 15 is Commerce and Trade, and it's actually Foreign Commerce and Trade. And in Chapter 15 or 15 U.S. Code, that is Trust Law. So when they talk about Sarbanes-Oxley, we're talking about trusts. They are operating in trust. And that is where they're supposed to have the attorney, specifically I've mentioned, they're supposed to have the interest on lawyer's trust account. In other words, each client is supposed to have their money put into a trust account and kept separate from all others. So that when situations like this come up and the accounting is inaccurate or they're committing fraud, you can get that money back. So let's take a look. This is from Gavin Mell. Gavin Mell. This is Gavin Mell here. Judge's son exposes court secrets from Birthright movie. So here they're just going to talk about the movie, but you can look this movie up and watch the movie as well. But we're going to get enough general discussion here that it should open your eyes. So again, please pay attention. This will be one of the most important videos you ever watch, reminding you that I've been right for the last 10 years, that the courts are committing fraud. The billing companies that are billing you are committing fraud. It's all tax evasion. They are stealing from your estate. I remember a judge asked me, where was my birth certificate? I asked her at the time, what does that have to do with this? That's the trust that they're stealing from. That's the estate trust that's established when you're born through the Bureau of Vital Statistics, where mom enters a journal from her private doctor when she was pregnant and has a prenatal chart. That's a journal. And when she goes to the hospital to give birth, there's a birth clerk that abstracts information and enters it into another set of information called a ledger. So they transfer information from a journal into a ledger. This is the monetization of women bearing children. Okay, so let's take a look.
And we're going to go into the movie premiere, which is called Birthright Movie. It's at Birthright Movie, and you could check it out on the at Birthright Movie. That's their X account. They also got a website, and Todd is one of the experts in the movie, including David Straight, including Ron Gibson, and many others. It's coming out on Thursday on Thanksgiving Day, so you can check it out on the premiere. And I want to have Lisa Writing give an introduction to Todd. So Lisa, welcome.
Thank you.
And some of you might recognize the name David Straight. David Straight, bless his soul, passed away this year. Another man in the forefront of exposing the criminal actions of the courts and the paperwork. So bless his soul.
Happy to be here today, and want to let you know I actually got to see the premiere and several of the groups that were down in Hollywood prior to it going out in the Independent Film Festival. And it's an amazing documentary. It's actually in 2 parts, and it's about a 4-hour documentary. First part is very focused on I'll let Todd talk a little bit more about.
When we look at the delivery room, the delivery room is a transfer of residence. This is where the term resident comes from. You're actually a resident in your mother's womb. And so when they take that journal and they create a ledger, what they do is they create a statutory person known as a state resident born in the United States. But that is a false conveyance, because if you're born in one of the states, then you're not born in the United States, because the United States is specifically located in Washington, D.C. Therefore, the only way you could actually be a United States citizen is if you were born in the United States. That means you would have to be born in Washington, D.C., somewhere where the United States is located within. Upon that, you also have to have a birth that is registered in the United States. Well, let me tell you something, folks. You can contact the Bar Association, and I'll pull it up before this video is over. But even the Bar Association will tell you there is no birth registration in the United States.
But basically helping you understand and comprehend the web in which works. And I have personal background with Todd, and he has helped me not only become a secure party creditor and a holder of due course, but he has also spent a great amount of time working with my family and my friends and helping us really understand what our rights are. Todd is not only spoke at the independent convention, he is a very much so very well respected in this space. He's a trust protector. And I don't know if you want to stalk his LinkedIn, but he's actually an educator. He's proficient at trying to get the cases out there and knowledge out there. But he's also a dear friend and a love for the Constitution and what trust means. So Todd, thank you so much for coming on and talking to our group. And also the movie is phenomenal. I encourage everybody to see both parts of it.
Thank
Yeah,
you,
the
Lisa.
movie was absolutely fantastic. I did get to go to the LA premiere and had a really good time with everybody. And it really hits home on a lot of things. And Lisa, of course, has another version of the movie coming out next year, and possibly some shorter clips of different topics and things like that for people to expand on specific topics people are asking questions about. And at the INC conference that I was asked to speak at by Robert Kennedy, it was pretty awesome to sit at the panel group up there, because they asked me to talk about two different topics. Obviously, one was about sovereignty and one was about trust. Because the group there for the presidential nomination wanted to explain to people how to use a trust to protect yourself and protect your family from overreach from the government, because that's exactly what they're doing. And I see it all the
Trusts are imperative to comprehend when it comes to this stuff, because the income is protected in trust. If they're trying to take money out of a trust account, they can't call it income. It's an asset. It has to be in a private bank account, a personal bank account, for them to be able to even consider it some sort of income. But if it's in a private trust account, they're not supposed to be even fucking with that, period. And that's essentially what the birthright estate established at your birth when you're born. That's essentially what that's supposed to be, a trust account. And what they're doing is they're dipping into it as secondary beneficiaries and clipping everything off the top without you knowing it. See, those benefits are supposed to go towards you, and they're holding them against you.
time with my trust clients that come to me that have living trusts that are getting smashed in the courts, and the courts and the government are taking over their trusts and liquidating everything for pennies on the dollar to pay creditors and things like that. And I see this travesty all the time. And I have to point out just the very basic concept of the IRS has this thing called a complex irrevocable trust. There's literally check boxes on the IRS documentation for what type of trust you're looking for. And that's the one they don't have jurisdiction over because it's private. It doesn't fall under the court and control test.
Exactly. See, they're not supposed to be touching them. They don't have control over them. The IRS does. Remember, the assignment of a social security number is in fact the assignment of a taxpayer identification number, and that birthright is establishing a private trust.
Because you split legal and equitable title. So that's the proper way to operate. It's the proper way our families operated for a very long time. But I thought at the conference, the most important thing that we got across were literally the other bar attorneys that were on the panel discussion. As soon as I dropped some of these cases and explained what was happening, they understood what I was telling the crowd there that was listening, that even under the cases like Perry versus United States, Chisholm versus Georgia, and Guaranteed Trust versus Henwood, the United States Constitution is a trust. We are the grantors, we are the beneficiaries, and
yes, King Cosmic says it's minimal contact in territorial jurisdiction. They call this minimum state contacts. Under Title CFR 20, the SSA and state get into an agreement with the birth certificate. This is the Health and Human Services in every state has to establish an estate trust account. And this is a state action, not an administrative court action. That's the fault in the boundaries there. Just because they're administrators does not mean they're supposed to have access to that trust. It's a matter of accounting. And if they're going to do it as a public accounting, they cannot have access to private trusts. Period. That's an IRS thing. That is not an administrative thing. They cannot just take over your private trust and administrate it for tax concurrences or tax occurrences, taxing events, and then evade the taxes on it, which is what they're doing.
Our elected and appointed politicians are the trustees. This is well known, well understood. Nobody argues this, right? Until we try to figure out how do you control your politicians. Well, if that thing is a trust, go ahead and revoke and revest it under the merger rule for trust and collapse it. This has actually been done in several countries in the last year. The main one that started this off was New Zealand, where the Maori basically.
And so when I've been speaking on this about establishing your own trust and collapsing that trust, that's exactly what I'm talking about. That trust is not valid if it's got somebody claiming you're the beneficiary and you have no access to it. It can't be a valid trust, particularly if it's done under the premise of Social Security, which says that you're a Medicare qualified government employee and you're not. Again, one of the false conveyances of that term resident. Under the federal code, it specifically says no person shall reside within the zone except federal, state, or municipal officers or agents whose resident presence is deemed necessary by the board. Whose resident presence is deemed necessary by the board, not just a pre-categorical classification upon birth, which is essentially what they're doing. Again, pre-categorically classifying you as a Medicare qualified government employee by using the term resident. Pure and simple. False classification.
Went in to the parliament and in their native tongue revoked and revested and shut parliament down. So it can be done, and it can be done under the striking clause, which is 5 U.S.C. 3331 through 3333 and 7311, because they're striking against Article 4, Section 4, the Republican form of our government, which was guaranteed to us and created a democracy, so we can shut the trust down, right? But it takes people to have enough nerve to walk into a House and a Senate hearing, right, in the middle of Senate, and as the
House and Senate hearing. What have I spoken about before on private law? You go to the House and Senate. That's Congress. You go to Congress and you have them delegate your private law, and it gets listed as a private law, and it's listed as a private law for the protection of the Keith Orland Little Estate Trust. Look at them. Look them up.
people revoke and revest the Constitution.
So Todd,
So that's when I name those cases and I name the statute to do it. That's when the attorneys like jaws hit the floor.
if there's any way you could come a little bit closer to the mic, it would be better if possible.
Yeah.
Or maybe turn the mic up. Yeah, that'd be awesome. So and then
So hopefully that makes sense to everybody.
Yeah.
The Constitution is a trust contract. It has to be, because somebody has to be the beneficiary of it. Somebody has to.
The Constitution is a trust contract. Okay? So unless you are involved in it contractually, you're only a beneficiary of it, not named. So unless you take an oath of office under that Constitution, you are merely a beneficiary. But once you do take an oath, now you are a trustee, and you are not to act as the beneficiary. That's the fraud, and they know it.
To administer it, that means there is a trustee, right? They gave us all the protections of the trust, and people are not understanding how to revoke and revest a trust.
Right. So can I take me back to kind of the beginning? And I want to know your story as well. And we want to start there in the beginning, but also the movie. So before we go, I want to kind of talk about your story. But before we do that, can you tell me about the movie? Because it was you and David Strait and other people in the movie that are really well known that I've already seen previews of. So how did this kind of come about? Where, how did you get involved in this film?
I was invited to speak at the conference as one of the main speakers and have several different sessions. And then while I was there, Lisa was basically like doing like a preview of the movie that she was going to release. And, we met and we talked through one of our other colleagues that we're associated with. And she was just like, oh my gosh, we're missing a lot of content, and do you have this? And I said, yes, I absolutely have certified documents of all of these things that I'm talking about. They're actually publicly available if you know where to find them. You can get certified copies of this stuff. And so we were able to bridge the gap on quite a few things that Lisa had been looking for a very long time that people like David Strait didn't have. He was very knowledgeable in that space about what they were doing, but he couldn't necessarily back it with real documents. So I've been able to, for like the next movie, I've actually been able to feed Lisa all the real documents.
And the same here. Even though I've been able to put a lot of this information together and connect certain dots myself, there are certain elements that I did not have. All of us working together is what brings this about. Remember that. It's about coming together in truth and righteousness and fixing things, not chaos and detriment and tearing things down.
Things like the Trust Indenture Act, right? That's like the attorney's kryptonite because that's what they're managing our trust under. They created that trust in 1939 and renewed it in 2010 so that they had the right to manage our estate and trust through our minor account. They're the custodians. They're the trustees. Right? Yeah. It's all right there, and it's all approved by Congress. They know what they're doing.
Now, a lot of the stuff's going to be over a lot of people's head who are going to see this in the beginning because you're like the advanced enforcement guy, and so take me back. But before we get to that too far, take me back down to the beginning. Like when you and I first met, you told me the story about how your dad was in the court, and then your neighbors were at the Federal Reserve. Can you tell me back to the beginning about where you grew up and how that all happened?
I grew up in the Bay Area in Cupertino, home of Apple Computer. And my dad was a judge and law school professor there. And he actually was doing that in the 70s and 80s when they switched over to this commercial bonding underwriting system for the courts because they were broke. And so they decided under Ronald Reagan's tenure that they were going to use the GSA bond. So they created the 1418 form, which is basically, it says it's a bond for anything other than a construction contract. So they started using
a bond for anything other than a construction contract. And so what they're doing is they access the minor account for the credits to purchase that bond. That's as simple as it gets. That's the initiation of buying a bond other than a construction contract. And I've been over this before as well with the taxes, insurance, and stuff on the postal site. It's a fidelity bond with the post office. Okay? When you remove that trust from the IRS and put it in the hands of a postal service, which is in fact a bank and a court, as well as the postal service, then I believe that is the correct hands.
Using those GSA forms to bond the court cases to extract money from the estate of the defendants so they could fund themselves. And my dad kind of flipped out and he's just like, and you want me to do this with no bonding and underwriting and no securities license? He's like, oh, hell no. And so I had to, as I was working in my dad's law office and parking and things like that, I had to write his checks to his surety company because he bonded himself. He's like, I'm not going without a bond doing this kind of stuff. If I get sued, I'm going to jail. He's like, no way am I doing that. So, he had a really hard time with that. And it just so happened that my dad was also the general counsel for my aunt and uncle's bank, the Arizona State Bank and Mojave State Bank. So, we would spend a lot of time during the holidays.
So the judge is also playing general counsel for banks and other companies. So they're playing judge on the bench and lawyers. Many of them are bar associates. Conflicts of interest, folks, all the way through, bias and conflicts of interest.
Days and summers and stuff.
That's why his daddy, as a judge, was so freaked out about doing what he asked him to do. Refused to do it without being bonded. Imagine that.
Like that. And I would go into the bank with my uncle, who was the president. My aunt was the CFO.
See, effectively, that irrevocable trust or that revocable trust that they establish is, in fact, a bond. It's a contract for bailment. Look at the thumbnail. It's a contract for bailment.
So I got to see the underpinnings on how, like, loans are not loans, they're an extension of your credit, because our next door neighbor was the TIL officer, the Truth in Lending officer for the Federal Reserve. So yeah, there's no loan, it's an extension of credit. This is actually extremely well known. It's documented in
Exactly what I've been saying. Those banks don't loan you money. Exactly what many people have been saying. Those banks don't loan money. They are extending credit. And they are, in fact, doing exactly like every other private company or public company. They are dipping into that minor account to establish the credits to set a bond. See, it's your credit, not theirs.
Title 12. It's documented all over the Federal Reserve's website. But you go into a court case and you say there was no loan, it was an extension of my credit, and they gaslight you. Well, fine. Then that thing is a trust. Revoke and revest that thing, and let's liquidate it. Let's go after the indenture trustee for embezzlement, and we'll take you in the U.S. tax court.
So it sounds so simple. So now let's go. So you're going up, you know, I know it sounds simple. You went right for the remedy as well.
And that's for every situation, because it is a commercial event. Therefore, it is a taxable event. Therefore, it's the IRS that has authority, not the administrative courts.
So your dad was a judge, and you're going to you're growing up here in Cupertino in the Bay Area, and then he realized there's a problem because of the insurance bonds. He's like, oh, we're going to get sued. I might get sued. Yeah. And Ronald Reagan apparently appointed him to this task force, or what was that?
He didn't appoint my dad in the task force. Ronald Reagan was the one that approved basically the use of the GSA bonds to fund the judicial system. They were broke.
Okay,
just like our government's broke now. So what do you think they're doing? They're filing 1099-As with no commercial paper. They're broke.
Yeah. So they're
broke. So they're filing 1099-As on your minor accounts in 1031 exchanges.
Making money on the bonds.
Insanity, what they think they can get away with, and nobody's paying attention. But under the IRS statutes, if they don't provide you with your 1099-A, that's tax preparation fraud. Because they're filling it out as they're the lender, you're the borrower. That's fraud. You're the lender, they're the borrower. They owe the taxes. This is tax evasion by our government.
So what led you down the road why didn't you just become an attorney, or what was the
attorney?
26 U.S. Code 1031, exchange of real property held for productive use or investment. This is your data elements. Real property located in the United States and real property located outside the United States are not property of like kind. So the data elements that you're using to establish that record at the state level, the estate, is not of like kind of real property located in the United States. Remember, I said the birth is not registered in the United States, is it?
Attorneys can only represent legally incompetent minors, right? They cannot do the accounting in the courtroom. You will be immediately sanctioned and disbarred. Can't be done. The attorneys can't do this. They're not allowed to. You have to have a really, and I apologize to everybody, but you have to have a really big set of balls as an attorney. You have to have a lot of clout to go into the chambers with the judge and do equitable subrogation and handle the accounting. They're going to be super pissed at you. right? Because you're not supposed to know to do that, and you're not supposed to do that to the court because it puts the court in a massive position of liability. If the client ever finds out, they have a tort against the clerk of the court, the judge, and all the attorneys. There's so much case law against them where they've been charged criminally for this kind of stuff, and the IRS has it. All they know is if this gets to the IRS, it's game over for them. It's a matter of time before they go to prison.
So, I mean, you're really advanced and clearly on another level. So I'm just wondering take me back more to the early days where how you're even getting there. I know you're.
American Bar Association, ABA, and it talks about a decentralized system, just like 1026 or 1031 exchanges. It's not centralized in the United States, but rather the birth is registered decentrally in each state. A decentralized system in the United States. There is no federal birth registry. Pursuant to 5 U.S.C. 301, that is a requirement. The minimum birth registration standards is that it must be registered in the United States. So when we talk about in the United States, this is where we're talking about the House and Senate and the private law. Registering that birth in the United States under private law, establishing a new revocable trust for the protection of the Keith Orland Little Estate Trust. Simple. As you might see in other nations such as United Kingdom, instead, birth certificates are issued by the states, which are obligated under law to report annual vital statistics data to the federal government. That's it.
So, your dad was saying, "Hey, we got a problem. I want you to learn this stuff." I mean, how did it even? Is that what happened?
Yeah, because even as the youngest child, my dad knew that I was inclined to this type of truth and this type of logic, that I wouldn't be corrupted onto the black hat side where my sister, my bar attorney sister's at. So she's on the corrupt side, and so I'm actually going to drop this into the.
So they recognize the two sides. See, everything in life is a duality. And like they say, there are good cops, there are bad cops. There are good attorneys, bad attorneys, good judges, bad judges. But the sides are not equal. It's a duality. There are more bad cops than there are good cops. There are more bad attorneys than there are good attorneys. There are more bad judges than there are good judges. This, I think, is patently observable.
The comments for everybody so you can see what the IRS uses against them, just as a basic primer. So yeah, he knew I couldn't be corrupted and that I would actually handle the trust. And even my older sisters, they all looked at me when it was time for somebody to take over the trust, and they said, "You're the best person for the job because you'll follow it to the letter." Like, even though I was the youngest.
Do you want me to open this document, Todd?
Sure.
I can share this. Let me share this on the screen. Hold on a second here. All right.
This is straight out of the IRS's own manual for how they prosecute the judges and attorneys.
Now, Todd, I think that as Gavin's bringing that up.
Let me share this first, Lisa, before we go in. We'll.
Now, I know this is kind of blurry for you guys because it's blurry for me too. But when you watch the video, you can slow it down. It's talking about the IRC section 7201 and 7201, 7202, 720, all the way through 7206, I believe. But here it says attorneys, like other taxpayers, are subject to prosecution if they commit tax offenses. And then it gives cases, United States versus Fisher, United States versus Kennison, United States versus Lindstrom, Turner versus United States, Rosenblum versus United States. So again, these are all cases that they come up with that prove there are standards for accounting, and it's regulated by the IRS, not by the administrative courts.
So
Go
when
ahead,
they're
Todd.
messing with your tax records, they're violating 7201 and 7206, right? They're doing tax evasion and they're concealing your accounting records from you. You see all
Attorneys
those
and
cases-
accountants.
Yeah, and you
See, and they're sealing your account records from you. They're hiding them, and this is one of the things that they tried doing in my case, and also as well as my companion's case when they came in and took money out of her account for a credit collection. So I'm threatening a full forensic accounting, and this is why. Because that money that they're taking unlawfully is they can be prosecuted for it, and you can get that money back. Okay? All those fines, fees, penalties, and everything you've been paying, you can get them all back. Your traffic citations, you're not required to register a motor vehicle for the Motor Vehicle Theft Prevention Program. That's voluntary, just like taxes, just like Social Security. It's all voluntary. But when you put those data elements in the record, it implies that you're a government employee, whether you're a federal, state, or municipal officer or agent, determined by your resident, your mailing address.
see all those cases right there. Those are all the ones that the IRS used against the attorneys and the judges doing this kind of stuff. That's just a basic list.
Oh,
They
Yes. King Cosmic says, like things deal with like things. Record Correction Amendment. Correct. These are corporate activities, and they're applying them against private individuals. That's an administrative Article 1 court being applied to a man when it's supposed to be an Article 3 court applied to a man. If you're an Article 1 court, then they can only bring suit against a corporate entity. The trust estate is not actually a corporate entity. The state is, and they're the ones holding the legal title. So effectively, what they're doing is bringing a claim of the state against the state and putting you in there as a state actor as the trustee.
this is the
liable.
enforcement.
That's the enforcement through the IRS. My dad actually was, he defeated the IRS twice because my dad was on the forefront of telling the attorneys and the judges that you better have your client's money in a trust account, like separated for each person in a separate trust account. So the Bar Association eventually.
That's the IOLTA I was talking about. IOLTA stands for Interest on Lawyer's Trust Account. You have an interest on that lawyer's trust account that he's supposed to establish for representing you. And if he doesn't, that's fraud too.
Adopted that, but it took a very long time. It took a lot of attorneys going to jail and prison for embezzlement before they forced the trust accounts onto people. But this is generally what they're doing anyways with the securities.
Okay, let's understand. Tribe, you're kind of correct there in a sense, but title goes to entitlement. And so when you're born in the United States, quote unquote, there comes with it an entitlement. So whether there's a document there or not, if there's evidence, then you are the equitable title holder, whether there's a title or not. See, the equity is the main factor. So even if there's not a legal title and you're in possession and using a portion of land that has no title, then no one has legal title, and therefore you are entitled under God. That's equity.
So what ended up happening, and I still have to defend this every now and then when my mom needs a loan because the IRS was so pissed that my dad beat them twice. They were saying deposits into his business account was income. And my dad's just like, no, it's not income until I transfer it to my personal bank account. It is a trust account to be drawn upon by the client when necessary. And so the IRS was trying to say that that was business income and it was personal income at the same time. And so he defeated.
And there's one of the presumptions that tribe is talking about. There is a standing presumption. And the standing presumption is that if it's in an account, it's an income. Sorry, you better have a definition of income, because as far as I know, there is no definition for income alone. Gross income, net income, yeah, but those are kind of ambiguous because that says from any source whatsoever. That's the presumption you need to beat with substantive facts. The income from any source whatsoever, excuse me, I got this from daddy. It was an asset and I inherited it. It is not an income. So when taxes are put on income or on inheritance, that too is false. No one has a right to what belongs to the father. Not Caesar, for damn sure.
Them in court twice, and the IRS is so mad that he beat them on the accounting that forever that those two court cases still sit as a lien on my mom, and my dad passed away, but it's still,
which is unlawful, because once the court has decided that he's won, they're supposed to remove that lien.
sits as a lien on their records. And the IRS, my dad petitioned the courts repeatedly to remove the lien because he won the cases, and the IRS refuses to remove it because they're so mad that he beat them with accounting.
Okay, so you
He was
learned
well versed on the accounting side. Well
I see.
versed.
So that's how you saw your dad win on these two accounting cases with the IRS,
Yes.
and that really, at that point, you learned that this strategy worked
Yes,
to
you
enforce.
can't get around the accounting, and you can't lie.
And so it would behoove these guys, and I'm sure he's pretty good at it, being a trust expert himself. I'm sure he will put clauses in his wills that those liens exist, but they are not valid, and show the court cases where he beat them. So it would be a carrying on of the facts in their trust wills throughout generations to prevent that from slipping back in. That's why they failed to remove it. If at any time some of his younger generations fail, they can slip that back in and claim legal title through a lien, which is false.
About it, you can't conceal it. And then since the Enron case, you can no longer conceal the accounting because the U.S. Department of Justice got busted for that. Enron got busted for it. So
Before I go back to Lisa, can you tell me about the Enron? I mean, I have a different perception on the Enron case than what you had. So what's the deal with the Enron case?
the Enron case, what ended up,
And pay attention here, folks, because this is not over yet. They're going to talk about the Enron mortgage default swap scams and what they did in 2002 with the Sarbanes-Oxley Act and that accounting. They just switched the mortgage default swap to what's called a credit default swap, because the common creditor, not companies that have big attorneys and big accountants that know all the accounting, but the common man, the common creditor to this nation, will fall under that and get duped that way. See, they merely spread it from those that could own houses to every man who applies for credit. It's the same scam. They're doing the same thing. The 1099s, tax evasion, dipping into your account because you don't know.
up happening is Enron, the corporation, they were selling power systems to Africa, and they were claiming that there was problems with accounting. And it turned out that Enron was doing their accounting properly, but the Department of Justice was trying to say they were responsible for the accounting for the people that were buying the power systems. That's not true. So Enron, the corporation, was acquitted in the appellate court because the Department of Justice basically lied and concealed the accounting records and lied and concealed the testimony of the people internal at the accounting department, right?
So the federal government holds the corporations accountable, and they have to show their accounting records, which they will tell you, you have to show your accounting records too as a common man. Meanwhile, they're the ones hiding everything and saying, oh no, we're not doing anything wrong, while accusing everybody else. That's what you want for government?
So the 4 Department of Justice tax attorneys and prosecutors, they all went to prison over the concealment, over the Brady violations, and one of them committed suicide the day before sentencing. So even though they got the Congressional Medal of Honor from Barack Obama, they all went to prison. So that should have been revoked.
Only one guy from Enron went to prison. All the rest that went to prison on Enron were federal workers, federal government employees. You know, those Medicare qualified government employees using Social Security, taxpayer identification numbers, and accounting against you.
Should have been more public news. And then what ended up actually happening is Kenneth Lay went to prison for securities fraud and for tax evasion because he had a TTNL terminal at Enron. And I have a copy of the transcript of the MoneyNet Daily Transfer Log 120. He was using his terminal to move credit from the
MoneyNet Daily Transfer Log 120. Now, we've spoken about this before too. That's the log that will show that you are in fact the actual original creditor.
minor account to his Bank of America bank account and not reporting it as income. So that should have been revoked. That should have been more public news. And then what ended up actually happening is Kenneth Lay went to prison for securities fraud and for tax evasion because he had a TTNL terminal at Enron. And I have a copy of the transcript of the MoneyNet Daily Transfer Log 120. He was using his terminal to move
MoneyNet Daily Transfer Log 120. Write it down, folks. MoneyNet Daily Transfer Log 120.
credit from the minor account to his Bank of America bank account and not reporting it as income. He got nailed for tax evasion.
So when the judge does the same thing to purchase a bond for the case so that he can get paid for residing over the case, it's the same thing. He's creating an income stream, but didn't report it as income.
That was the actual crime.
That was the actual crime. Kenneth Lay using his TTNL terminal to move credit and create an accounting transfer, a deposit into his Bank of America bank account.
And that's what the courts use through the clerk and the court registry investment system is a DTNL system. So they're doing the same thing daily for every case. And it still goes on today. This happened in 2002, and it still happens daily for every case. So where is the accountability if it doesn't reside in you? It's your accountability. You have to learn this stuff so you can hold them accountable. Nowhere else will they be held accountable. None.
Wow.
Right.
Lisa, did you want to add something?
Sure. What I think, Todd, I think would be great is not only an introduction to the movie, but I think that those that may view this, because it is going to be public, is let's go back to the very basics and explain that for every court case, there is a deposit underneath the 28 USC 2041, and that they create securities without you knowing it and without you granting permission. So can you explain?
And so that deposit, again, is coming from your estate. They dip in as the beneficiary and say, hey, I need this to purchase this bond. And that's how they fund the cases, like I just explained. They're making that deposit through the court registry investment system. And I've showed this many times. The obligor is the social security number they're using, and the name is not the last name. They're using a firm name, which is a corporate entity name. So they're implying that you are operating as a corporation in an Article 1 court and have given them permission to extract the money to create the bond.
A little bit more about that and then why the gap accounting comes in. So can you do it in two parts, the first and the second?
Yeah, let me get a record for everybody here. I'll drop it into the comments. Just give me a second. It's going to be the.
If you want to hold them accountable, learn their accounting. GAAP, generally accepted accounting practices and principles. This is the double entry ledgering. You people, me, everybody in general is never taught the double entry ledgering. We're taught the single entry ledgering as that in a checkbook, but we're never taught the double entry ledgering.
1099 A and C instructions from the IRS. A and C. So this is going to blow it out of the water. Here's your proof. Because you're not going to find the proof anywhere else that they're doing this other than they have an administrative agreement with the IRS that authorizes them to do it, okay? Let's see, desktop.
I have, do you want me to, are you having a hard time pulling
No,
it up? I have
I've
it.
got it.
Okay, good.
I just got to see where I put it. Here we go. Okay, so Gavin, if you want to put that up on the monitor for everybody.
Yep.
No, not actual title, in name only. But a man is not a name. Correct. A man is not the identity. Correct. 20 CFR 402.103 specifically says the individual's name and social security number identify the record. It goes to say as well across the board, the individual's name and library number identify the library record. The individual's name and driver's license number identify the driver's license record. The individual's name and student ID number identify the student record, the school record. It never identifies the man.
And believe me, I've been in front of state clerks of the court, federal clerks of the court. They surround me with sheriffs. They surround me with U.S. Marshals. I don't care. I literally look at them and I say, I'm here to make sure that the clerk of the court doesn't go to prison.
Yeah, and see, that's one of the things I figured out in my earlier days. I was going to go after these guys. And I thought, no, something inherently told me that's wrong. That's not in my heart. I don't go after people. I just want to make things right. So in making things right, I have to give them a caveat. Hey, listen, you just allowed a bank to take $3,800 of money out of my companion's account. I want a full accounting. And if you don't give me that full accounting, then I will hold you accountable. You give me that full accounting, then it stays in the record. It doesn't come out and grab you. It shows that you acquiesced and said, yeah, maybe there's something wrong. We don't want to be doing anything wrong. So we'll give you the records and we'll figure this out together. That shows that you're not acting in bad faith. That shows that you're acting in good faith with the good people of the land. See, it's bad things happen because good people let it happen. That's your accountability. If you think you're the good people and these are bad actors, then you have to hold them accountable. Ain't nobody that's going to sit beside them going to hold them accountable because they're bad actors too. Yes. Yes.
Here's my documentation
Indemnification.
that they're actually doing this, right? So I'm here just to get documentation from you, which is required by law in the Internal Revenue Code. So if you scroll down to page 3, and we're going to go to section section 5 on page 3. I think went a little too far. We're on page 5.
Okay, page
down.
sorry. Page 2, page 3. Here we go. Oh man, this thing goes fast.
Page 3. Yep. So number 5C. Oh my gosh, who's filing a 1099A? A court.
And I know you can't see this very well again, but it's a court or court administrative office. This is what gives them the implied the impression that they are automatically allowed to do this, and it is not. Just because you have some thing that says a court or court administrative office doesn't mean that you're automatically allowed to do it and then hide the accounting. See, if you're allowed to do it, then you have to have the proper process of authorization. Like the man was saying, his father didn't want to do certain things, so instead he did them for his father. He acted as his father's representative. There was an assignment to do so. Under this public trust, there is no actual assignment of a man. Again, the assignment is that of a number to a person, creating a record only.
Or court administrative office. So a 1099-A is proof that they have acquired your secured property or that you have abandoned your property. You've abandoned your bond. So the 1099-A also has to be coupled with a Q-SIP, right?
Correct. Is this why public and private do not mix? They are not like things. Correct. That estate trust that's established when you're born is a private estate. It's handled by the state, which is a public entity, but they are not supposed to mix it. And that is exactly what they're doing. They're mixing it by that term resident. You are now acting as a state employee and using your social security number, which is that private trust.
So that's the tracking number for the bid performance and payment bond that's in the C.R.I.S system, court registry investment system.
Bid bond, payment bond, or bid bond, performance bond, and payment bond. You have to bid for the contract. Remember, they talked about bonds for other than contracts. There's a bid for a contract. And then you have to show that you're going to perform the contract. In other words, lay the foundation for the contractor. Okay. And then you get a payment. You bid for the contract, then you perform the contract, and then you get paid for the contract.
And so, yes, they have created a bond. There is a Q-SIP for it, and they use the 1099-A to extract the credit from your minor account to fund the bond. Okay. So, and there's plenty of they have acquired your secured property or that you have abandoned your property. You've abandoned your bond. So the 1099-A also has to be coupled with a Q-SIP, right? So that's the tracking number for the bid performance and payment bond that's in the C.R.I.S system, court registry investment system. And so, yes, they have created a bond. There is a Q-SIP for it, and they use the 1099-A to extract the credit from your minor account to fund the bond. You've abandoned your bond. So the 1099-A also has to be coupled with a Q-SIP, right? So that's the tracking number for the bid performance and payment bond that's in the C.R.I.S system, court registry investment system. And so, yes, they have created a bond. There is a Q-SIP for it, and they use the 1099-A to extract the credit from your minor account to fund the bond. Okay. So, and there's plenty of stuff in Title 31 with the Treasury Department that says they're authorized to do this. If you really want to hunt for it, I have that too. So, yes, they are actually doing it. There's your proof. What else do you need, right? How much more proof do people need that they're concealing and removing the accounting and the securities from the court, which is a violation of 7206, right? 7206 from the Internal Revenue Service. They are removing the accounting and the securities to defraud you as the grantor, bailor, owner, and beneficiary, right? And that is a trust. Securities are held in trust. So when you revoke and revest it and they don't liquidate it, now they're into embezzlement. They're operating as what is called the incidental beneficiary committing defalcation. Okay, that means that they're acting as a beneficiary to that security when you're the beneficiary. Defalcation means that they're embezzling it from you.
So Todd,
These are legal terms that the IRS uses for this process of them embezzling the securities when you've revoked and revested.
You mentioned.
Okay, I got to take a break real quick. I'll be right back. Please enjoy. And we'll be right back, folks. Be blessed.
I am accounted for, my name's been read, written in the ledger where the lamb was led. Did not the body, did not the blood, pay every debt in the flood of love? So tell me now, what's left to owe? When mercy calls, I can't say no. Are we too old on anything? Just grace erase what the law might bring. If love's the all, then love fulfills all that binds all their wills. bend, the temples fall, but the heart still whispers through it all. Render to God what is divine, and what remains is only mine. So tell me now, what's mine to keep when every truth cuts dark and deep? Are we alone, no matter anything? Does the blood absolve the suffering? If love's the law, then I am free. But is that law the law of me? If I am bought, I am not sold. If I am dust, I still am gold. The measure's met, the balance true. No doubt remains, save love for you. Are we to owe no man anything? Did not the Christ pay everything? The law fulfilled, the veil torn through. Now the law of me is loving you.
Mentioned earlier someone who was well known. A lot of us have heard of. I mean, Gene Keating. I guess maybe. What's the story with Gene Keating? How do you know him, or who is he?
I know him because I worked with him a little bit on certain specific topics, because he's obviously probably the nation's leading expert in bonding, underwriting, securities, uniform commercial code, and how the entire process works with the court, because his two brothers are also federal judges, and they essentially ratted out the system. So Gene Keating had a document, I think it was called Cracking the Code, if I remember right, which he explained the commercial nature of the courts, and he pulled out all the case law, statutes, codes, everything that they were using to operate the court on the commercial side, right? So I do have a memorandum of law for that. I do actually train judges and other attorneys that need training. So I actually handle the bonding and underwriting commercial securities and their liability for what they're doing when they get caught.
I saw on your LinkedIn you have a number of I mean, you like a lot of things I didn't understand. There's like BTC and a lot of these things. Can you go over your background a little bit on what you're?
I mean, my original background is I was a chief information officer in the pharmaceutical industry. So I have advanced degrees in biochemistry and immunology, and then MBA, and then work through the JD and things of that nature. Geared toward just doing the trust stuff, because when my dad was getting older, somebody needed to take over the trust. So I had to learn that side a lot more effectively. And then it got to the point where I was having to sue banks, right, and having the internal knowledge of how the banks work and on all the mortgage.
And so it would seem that Daddy helped him learn much of what he learned, aside from any education that he got in college. So again, the education, when you hand your children off to a public education system, that's part of the problem. We should be teaching our own children. We should be teaching our own children everything we know so that they can be better than us. Instead, we hand that off to somebody else that doesn't have any interest in teaching them other than a paycheck. They don't want them to be, the teachers at school don't want their students to be smarter than them. So when a student is making profound statements, they're the ones that get sent to the principal's office. They're the ones that think outside the box and cause a distraction with the other students and help them learn how to think outside the box. And they can't have that. That's why it's so important to understand the imperative nature of teaching your own children.
Fraud and stuff like that that's going on. And it's the same thing. The mortgage stuff is all a trust. It's all accounting fraud. It's gas violations. But because of my background and what I did with forensic auditing and things of that nature as a forensic auditor and consultant in that arena, to the big real estate companies, the big brokers that are doing mortgages, Berkshire Hathaway, I consulted them for 10 years. Douglas Elliman, Prudential, Remax, Coldwell Banker, all the biggies, right? So I was brought in at the corporate level to explain to them how to use a trust to protect their clients and how to understand what's going on with the mortgage in the securitization of the paper under Article 3 and Article 8 and 9 of the Uniform Commercial Code. And that it's all about the accounting and the trust. And then you start eventually running into people that work in the equity realm on Wall Street. And
remember, I spoke about the United States, and location in the United States is located in Washington, D.C. That's from UCC 9-103. Location of debtor. Debtor in relation to the accounting. Now we look at 50 USC 4309 B2, and that's under the Trading with the Enemy Act, and it talks about in the interest of the United States and for the account of the United States, full acquittance and discharge for the person making the same, so that no person shall be held liable in any court. See, you're removing the liability from the people and placing it on the record, and that is the problem. See, it's the record that's in error. Okay, it's people have been putting this information into the record so long they don't understand their errors, and it's just a record. It's not the man, yourself. It is the man in the case of the bad actors, those that are doing things behind the scenes and committing fraud and all that. That is them. But again, we have to go forth with the perspective that forgive them, for they know not what they do, and be an informative person and give them notice. Hey, clerk, I noticed that you allowed this case to go through, but I also noticed that this is an Article 1 court where my companion not only is retired and not acting in a corporate fashion whatsoever, she herself is not a corporate entity, and she is disabled. And therefore, your accounting in this case is in fact in error. Matter of fact, it is so much in error, she will get on the stand and testify that she gave no authorization to access the minor account pursuant to the money daily net transaction log 120.
they fully disclose to you that, yeah, they're selling that security. They're not doing a tranche anymore where it's like the 50 pieces of the security. They're selling the whole.
Yeah. Remember I told you before, it was much like independent contractor that mows lawns. He goes down to the local convenience stores and stuff, and he puts up flyers. And at the bottom of the flyer, it's got little strips that you can tear off with his number on it. You can call them. That's called a tranche. And they would sell one little ticket. They would sell them off in bunches of little tickets. Now they're just selling the whole security all at once.
Security 50 times. It's insanity what they think they're getting away with and not paying taxes on that. And then you eventually ran into IRS Criminal Investigation Division people that were mortgage fraud investigators who their job was to actually audit the courts and the banks and to fine them for all the violations. So that's why I also put earlier, I put like one of their, did I put that in here? Yeah, I put the violations as like very first thing in the comments. If you want to pull that up, that's the basic list they hit them with.
Yeah,
So
that was the
to the courts and the banks, because remember the court is a bank, right? There's a they're selling private commercial security.
I would never step in anymore. I will never step in their court. They would have to drag me in. I will do it through private communications and simple wording. Listen, that summons doesn't apply to me. You want information. And if you want me to give the information, you're merely asking me to reiterate what's in your record. I can't do that. I don't have your record. What I can do is I can pull up the money net daily transaction log 120 and show you that all of these bonds that you created were done in that name, and that was not your authority to do so. That is a 3949A or a 14242 according to the IRS. Trust fraud. Sarbanes-Oxley Act, like I've been saying for a long time. I filed it in my case 10 years ago. I've been working on that ever since. If you listen to Derek Gonzalez, he says the same stuff. We're doing the same research, but we don't communicate with each other.
Securities, so gap and gas applies to them.
This one?
Yeah, no, the very first one, 091 violations. The very first one that I dropped in the comments.
Okay, I'll have to grab that one. So
yeah, when you understand the rules and how they work, the court can only obtain personal jurisdiction by the plaintiff properly serving the defendant in the state in which the court sits. And in an Article 1 court, that has to be a corporation, first and foremost. So when they serve a individual man that doesn't have a corporation, that is not proper service. So there was no proper service, period. The second part of that is that the defendant needs to voluntarily appear in court. So if the court has neither one of those, then where is their enforcement? They have none.
So back to the,
that's
while I'm
how
looking
I
for
kind of
that.
run into all that stuff is you start to have to learn and understand what they're doing, and everything's in trust. And as soon as you understand the basic concept of a trust, that you can revoke and revest anything that's a revocable trust and collapse it, and then they go on the run. Then they start concealing stuff, and you start finding out they're lying to you, and they won't disclose anything. Well, guess where they can't lie about the accounting? U.S. tax court, right?
Violations.
This is the basic list that the CID goes after when they're auditing a court or a bank.
18 U.S. Code Section 153, embezzlement. Along with that, they knowingly do this, and they are supposed to report felonies. So if they see their partner doing it, they're supposed to report a felony. That's 3 years for under 18 U.S.C. 4, misprision of felony. That's the hiding part. They're all hiding it. They're all supposed to be reporting it, and they're hiding it.
So you're saying that the court has to.
The court has to keep their accounting. The court took the accounting out many years ago because people were collapsing court cases very easily because the judge had a terminal. The judge had access to the accounting, so they removed the accounting from the court so they can play dumb, right? Plausible deniability. We've never heard of this before. Accounting, we don't have any accounting records. Well, that's because you violated 7206. This is fraud and false statements of concealment. You removed the accounting and the securities from the court to defraud me. Those things are a trust. Everything in this court is a trust because it's an administrative court. It has to be.
And that's why I say go after the clerk then, because that's where they moved that facilitation, that access. The clerk has access for damn sure. He is the accountant. When you go to the court to get an accounting of all of your civil and criminal records, you go to the clerk of courts for that accounting.
Dealing with a trust somewhere. There has to be a bond somewhere. You're administrative. You cannot get around this. This is how you're structured.
And there was I'll see if I can find it. There's a funny video that I saw that on your LinkedIn page about a guy going into court and then he left his camera on and then the judge was talking about, you want to talk about that?
Oh, yeah. That was for a case that we collapsed. And so the lady was in the courtroom and she revoked and revested in the courtroom, did everything she was supposed to do, equitable subrogation,
I was just going to say, this has to do with equitable subrogation. That's a term a lot of people don't hear is subrogation anymore. Subrogation is in regards to the financial aspect of things. This is a letter of rogation. Letters rogatory. Okay. And that's what subrogation is. You're returning it back to what it's supposed to be. Because in the rogation, it was aired. It was entered in error. They entered in as the beneficiary, and they are not the beneficiary.
Discharge, and the judge flipped out, the prosecutor flipped out, And so after she left for the day, because they wouldn't do it, which is now a felony, so she's going to U.S. tax court now. The prosecutor was sitting there disparaging and bad-mouthing the IRS. And so I sent a copy of that to the IRS Criminal Investigation Division, and let me tell you, they are hot. They are just like, you do not revoke and revest, and then you guys sit there and embezzle everything and then badmouth us. They're just like, we're coming for you. We know who you are. We have your picture. We know your name. You are going to be audited.
Whoa.
Yep.
You are going to be audited, and they will audit every fucking nook and cranny. These are public officials, and they will subpoena the record. That's where all the shadows are. That's the abyss.
Don't mess with the IRS. When you revoke and revest, do not mess with the IRS. They are coming for you. And those are some of the statutes and issues they're going to use against them. And you see all that case law they're going to use against him. Right? That guy's going to prison.
So has this ever happened? I mean,
and one of those is, in fact, identity theft. And that's what I was saying with the enumeration at birth. It allows for identity theft because they hold it in state hands. And whether it be assumption or knowingly, they're taking that private estate as public property.
obviously, I saw those other cases. This has happened before with a lot of
You
this.
saw the cases I gave
Yeah.
you to. The IRS
Yeah, you
uses
did.
those against them. They're going to prison.
Right. That's all these cases here.
That's straight out of the IRS's own playbook. Yeah, so like I said, it's like 1,200 pages long. I have it.
So this is just the one about, the attorneys. Yeah.
Yeah.
Whenever the attorney does that.
Yeah.
And you can get a hold of this guy. Let's see here. They're going to show it on Lincoln here pretty soon, I believe. Yeah, here in a couple minutes, they're going to show his profile on Lincoln, and you can get a hold of him through that Lincoln profile and ask your own questions. See if you can't get your own resolve. See if you can't get your remedy. Look back in your life and find and remember how many traffic citations you went to court on. Go down to the clerk of courts and ask them for the full accounting of both your civil and criminal record. You need it for taxes.
So remember, 7201 is tax evasion. 7206 is concealment. Government lawyers, right? Criminal defense lawyers, tax lawyers, real estate lawyers. Yeah. You don't get to conceal the accounting anymore.
Right.
They're done with you people. After Sarbanes-Oxley and the whole Enron debacle, they're done with you. You can't hide the accounting anymore. So what we're seeing now is when you go into the courts and we basically specifically state, are you striking or denying Sarbanes-Oxley and the Securities and Exchange Act? And they say yes. Say, thank you very much. That's a willful felony. You have no authority to or plenary powers to strike an act of Congress. This is how arrogant they are. They don't think the IRS is coming for them. Because too many people have threatened them with Form 56s over the years and the IRS never showed up, or 211s and 3949As, because you got black hats inside.
3949A. That's the one that I filed 10 years ago. Oops. 10 years ago in my case. And what they do? They filed a protection order against me and then renewed it 5 years in a row because I was reporting them for tax fraud, estate tax fraud. Think they got away with it? Statute of limitations doesn't run out on fraud.
The IRS that won't charge it. So that's why I'm telling people we're at the stage now where they're so arrogant that we just have to file TTAM and U.S. tax court, but we have to ramp up the documentation to prove that they embezzled from you. When you revoke and revest and they don't liquidate that trust for you and do the discharge like they're supposed to, that's willful embezzlement. It switches from a civil issue to a criminal. So you have to understand Internal Revenue Manual 25, I think it's .1.
Again, like I've been saying in my videos here lately, it's not corruption. That's a civil term. When it turns criminal, then it's criminal. So when they turn something civil into a crime themselves, you don't call it corruption. You call it criminal.
Or .1.1.3, and then 9.1.3, which is the criminal statutes that the IRS uses for the 7201 and 7206 violation. This is what they're doing. They're broke. They're embezzling. They don't have any other choice but to embezzle. Remember, they were told after the whole Enron debacle and the mortgage housing collapse and stuff like that, that they set everything up to do a bail-in, right? Well, they're so scared about people found out that their plans to do the bail-in that now they're just straight embezzling. They're just straight doing 1099-As. So they're not doing necessarily a bail-in. I would say they're doing a bail-in from the Treasury Department because they're using their terminals to go after the Treasury and just move ones and zeros, do book entries everywhere. No commercial paper.
Todd, I saw that it says you're registered with the IRS and DTCC. What is DTCC for people?
The Depository Trust Clearing Company.
So his name is Todd Dwell, trustee and trust protector. He's in Oceanside, California, United States. Graduated from University of Phoenix, TAD Trust. And services, accounting, executive coaching, leadership development, negotiation, public speaking, training, business law, family law, legal consulting, property law. And you can hit that request services. Okay. And I dropped the link to this video down in chat, as well as it's on the screen. Feel free to copy that down. Go check out the video yourself, as well as Birthright, the movie.
Well, all my securities are registered with them. So basically, they know nobody's supposed to be touching my securities. So when people do things like they did 2 months ago and did 2,500 1099-As, that's why I flipped out at the IRS and said, I'm going to find out who did this. I'm going to pull that individual master file, and they're going to get charged. Get off my minor account. Stop doing tax records for me. You're not authorized. I have all my stuff filed with the Social Security, IRS, DTC, all of them. I have all their own forms, their own statutory forms. Tell them, get off my account. It's locked up. What are you doing in there? Who gave you authority? You don't have power of trustee. You don't have power of attorney. Agency agreements are terminated. I filed all.
Assumed power of attorney. This is why it's important to establish your own irrevocable power of attorney under sound mind and body. No one has authority over me or my property. And unless I have created a document assigning them that authority specifically from myself to them, they have zero presumption they can present as being qualified to do that. Again, it's a state legal title established, not an administrative court. And therefore, they have no permission from the state. It's only presumed. And they have no permission from me. It's only presumed. And they're playing that beneficiary position, initiating it to extract the credits to establish the bond that which they can then perform their judgments on and get paid.
All your forms to stop all this stuff. Who's letting this go through? All this stuff. And I contact them. They say, yeah, we can see that in your records. And I'm just like, then who's allowing it? Why are there no safeguards in these terminals to say that that account is locked? That is the problem. The TTNL terminals are so old, they don't have any safety mechanisms to show that the account is locked. And whoever's doing the pull isn't checking the commercial records, and they're not double checking their agency agreement to see if they're allowed to do it or not. They're just straight.
Yeah, and if I think the importance of that MoneyNet daily transaction log 120, if they would simply check that, it would verify that the one accessing the account is not in fact the creditor, and therefore must trigger a search for the power of attorney that allows them to do so. Very simple mechanism, and yet they don't do it. Again, another reason why it is imperative for you to understand you are the one that should be accountable. You should hold yourself up to the integrity of knowing so that it doesn't happen to your children.
Doing it. And like we said earlier, they're doing it with no securities license because they can't get licensed and bonded to do this. It's illegal.
Here's the website for the movie. I saw Sabrina, you asked about it, and it's going to be on the Thanksgiving Day. Link will be posted on here on November 27th. Birthrightmovie.com. Birthrightthemovie.com. And it's got a lot
So
of
does that
people.
mean it's only going to be streamed on this?
Birthrightthemovie.com. Birthright the movie.com.
Day on Thanksgiving, or will after
It's a new,
Thanksgiving will we have access?
I don't know, but it's just a new movie. So I think they're doing a preview here on this website before. Do you know, Todd?
When it's going to be streamed?
I know it's going to be streamed on Thanksgiving. I'm not sure about after that. I think it's a
Lisa,
premiere.
That's Lisa's question.
Lisa, I have a question or a suggestion. Are you familiar with Angel Studios?
I am, and I know that they're trying to get this because they've now been through the Independent Film Festival and they've picked up some funding, and so they're releasing it. I think it is a pay-per-view, and so is that what you're asking, Sabrina? If we can get the link that you can watch the first section of the Birthright movie?
Yeah, well, I think the link was posted, but I have a client who works for Angel Studios, and he told me, because I talked to him, actually, I was asking if they showed this birth movie, and he said, no, but it sounds really interesting. And he gave me kind of like the formatting to go through to get the movie approved. And it could, because Angel Studios is a streaming, they're a streaming, I don't know, company.
And that's the thing about the AI that I'm getting into now. I have a screenplay written and I want to produce it. And I don't want to go through a movie producer. I want to stream it myself. I want to produce it myself. And this is the unique aspect of this internet, this World Wide Web, and the AI and its capabilities in allowing you to do what whole industries do. So we no longer have to go through movie theaters and movie productions. We can go through independent producers that stream. Remember, it's a bigger movement than you might think. It's moving all kinds of things around, and it's placing a lot of things right at your own hands if you learn how to use it. It's not bad if you understand it and use it properly.
And so, but it's all like it's all, very conservative valued, and any movie that's put on there has to be voted on by the board. And so if that's something you're interested in, I have a connection there at Angel Studios. I just met with them last week.
We can definitely forward it on to the right people. So we really feel like everybody should see this. And what I think is my personal, testimony about this movie.
So Angel Studios, one of the first in the market. Look them up if you have an interest like mine, which is what I'm going to do. I'm going to be looking up both Todd Duell and Angel Studios and getting in contact with them in regards to my own contemplations and projects I want to get moving on. Start learning and connecting with these people that are coming into these new forums and be part of something new. And remember, you got to hold yourself accountable. Not to anything, but the knowledge of truth.
Is I've studied this for 30 years. And after I met Todd and, I wasn't afraid anymore to basically.
I feel blessed. This woman spent 30 years. I did it in 10. Of course, I imagine she didn't sit at a computer desk day in and day out and put in over 20,000 hours worth of research because she had other things going on in her life. I'm one of those guys. I really don't give a fuck. So I did what it took. I got rid of all the bank accounts, the job, the employment, the IDs, everything. No social security card, no state ID, no bank accounts, nothing.
Stand up when you start looking at they're charging basically your corporate entity for administrative or crime. They call them crimes, but what I'd like Todd to talk about is, you know, if you're in court and you're asking the nature of the accusation or the nature of the charge and what jurisdiction they're falling under, and the fact that they're creating securities on your behalf, we have to all look at ourselves as they think that we are the battery. You know, like, I know we're going back to the Matrix, but it's a way that people can understand it. And so we have been teaching people to document, even in an Excel spreadsheet, every single thing that we think that we've done in commerce, from your driver's license, your birth certificate, your passport, your every court case you've ever opened, either been a plaintiff or defendant of, every traffic ticket. When you really look at this, we did it on my family. And what I was shocked when we traced even our kids, their student IDs at the university had Q-SPID numbers. They're committing fraud every single day. And they're also, because if you go back to the Constitution and you look at the protections that we have a right to a jury. These administrative courts, 99% of them are done through plea bargains, and they're done through, you know, basically summary judgments or others.
Or they'll force a bench trial on you, no jury.
Yep. Lots and lots of elements. When you put
My apologies. That's one of the unique things in my case. I didn't want a jury trial because I understood already the resident United States citizen, and placating that if you're on a jury, you got to present that state ID as a government employee. That's not a jury of my peers. That's a set of people that are government employees that don't realize it, and they're acting for the government. Okay, so it's still a biased system. So in my perspective, I was looking at the financial end, and I knew the only one that would be responsible on the financial end would be that judge and the clerk and the attorney. So I demanded a bench trial. Now I can hold him accountable, and he has no way to set it off. Oh, the jury said that. No, you made that decision. You knew it, and you still made the decision to send me to jail for 60 days. And then the bitch on the other side of the counter tried to tell me I had to sign another document in order to get out. That would be taking on the liability of my jail stay. I already had a discharge order from the judge. Funny, they still have that account. Funny, it still says it's not been paid, nor does it say it's been discharged, despite the fact I've still got the document saying discharge.
when you start picking the scab of this problem, it's a bleeder, it's a gusher, and you have to learn to absorb, like, really what is happening to the commercialization of the human being. It's alarming. And so this movie brings out that nature of it, but it also talks about the bonding. It talks about all those elements. But go ahead, Todd.
Yeah, it does talk about all that. And like Lisa was talking about there, I dropped into the comments for everybody, you know, your basic like court appearance, whether you're appearing, you know, in an administrative court, you know, and things that you need to say while you're in there too, because you have to catch them on certain jurisdictional issues. It's to the point now where you go in and you ask, or you even put a memorandum of law around the Sixth Amendment nature of the accusation, they strike it. I strike the Constitution in a traffic court, right? They basically know they're just setting themselves up to lose, right? But what do they want you to do? Appeal and open another bond so they can laugh at you, right? And they're striking equitable subrogation. So you're just like, there's nothing else. It's an administrative court. We're dealing with the accounting for the securities. So this is the kind of dumb stuff that they're doing. And they're making it progressively.
And that's what I was saying about the litigation being drawn out with continuances and this and that and forcing you to appeal. That's a game. It's a money shell game. That's why I'm not going to go into those courts. You're going to have to force me into those courts. And I will never sign anything. Give unto Caesar what belongs to Caesar. Give unto the Father what belongs to the Father. Period. That's this Christian society's rules.
more worse because of the people that have figured it out. So I also dropped into the comments there a UCC filing that I have, it basically discloses to everybody on the commercial side the private power of attorney revocations that I have with the different agencies using their forms to let everybody know, get off my records, get off my tax records. Okay, what are you doing in there? That everything is blocked, right? Everything's registered. There's a lien on everything. And if you create a trust for me, you create a security for me, I'm going to take you into U.S. tax court for fraud, right? Giving them public disclosure.
See, that's the importance of the UCC1. It's not anything but a notice of lien on your property as the first liener. You're making a claim to your property. That's all it is. You're not placing a lien against anybody else. You're placing a lien on your property, locking it up, as he says, so that if somebody else tries to access it, you've already got a record saying that's mine, and they accessed it without authority.
Public notice, because if these agencies aren't going to put a block on it, I'm going to put it out in the public domain. There's a block on this. These agencies have copies of these forms. You're not supposed to be doing this. Right? This becomes a very powerful exhibit in the court to look at a prosecutor and say, how did you step through my these powers of attorney that were revoked? So this isn't the whole thing that Mr. Straight was doing, revocation of election. That's a notice. That doesn't do anything. Notice does nothing. When you're in the statutory realm and you use their form.
So when you hear all these gurus talking about revocation of election, you never made an election. It's nunc-pro-tunc. You were determined to be a resident by election of somebody else, not yourself. Medicare qualified government employee, resident of the state upon birth, fails to meet either standard of being born in the United States and having the birth registered in the United States. Everything's a presumption, and until that is cleared with your revocation of powers of attorney, a notice by law. First duty in law is legal notice, not just some revocation. That's not a notice.
You block them. Now they're not following their own statutory rules, are they? And you've got liens on everything. You've given them notice of what they're doing. They're creating securities.
Yeah.
Right.
And I'm going to go to
So
Catherine with your hand
so
up. Before you do that, let me
not-
just comment on notice really quick. That's a really good point that you made, because I think a lot of people who have tried to go to court or do patriot stuff, what they do is all these notices, and notices are just notices. That's all they are. They take notice and that's it. They have no enforcement. So
No.
that's the big difference.
Yeah. Now, when you understand equitable subrogation, right, where now you're throwing your debtor under the bus to discharge the liability, now you're throwing the liability back at the court to do the accounting.
So the discharge that I got from the judge was a discharge of liability. Understand that? So when they wanted me to sign the release paperwork, it would have placed the liability right back on me, because then I would have been releasing my personal services as a corporate entity.
And if they don't, and you revoked and revested that trust and the accounting, and they don't do it, that is a willful criminal act of embezzlement of your estate funds that are there for equitable subrogation.
Catherine,
They cannot, they try to get around this, but when they start denying equitable subrogation, they strike the Sixth Amendment, they strike Sarbanes-Oxley, Securities and Exchange Act, strike the Federal Reserve. At a lower court level, a state court or lower, this isn't no congressional authority. This is right for U.S. tax court, right? Right for U.S. tax court. Absolutely.
No congressional authority. None. Zero. Zip. Nada. They are supposed to administrate according to the congressional law, not state statutory interpretations of their own.
Todd, can you talk a little bit about your quote administrative process, which when you ask for the Q-SIP, is there something more to that, or is it just
Yeah, that's
I disagree. Freedom with Equity says, I disagree. Notice does have power when issued. The problem there is that it has to be issued, like this man said, in accordance with other documentation. So the notice is a notice of revocation of any presumed powers of attorney, a notice of direct power of attorney within self, and of course, like he says, notice of the Sarbanes-Oxley Act, the Sixth Amendment, anything else, identity theft, this and that you want to use to show that they're acting in securities frauds without a license to do so. See, if they had congressional authority, then they would have that license, but they don't have that license. And that's what says they don't have congressional authority. That licensing can only come from the man, the actual living soul, giving a power of attorney to somebody to enter that private estate for commercial transactions on his behalf.
Fraud and false statements and concealment when they don't provide it. It's a Sarbanes-Oxley violation under 7206. You go to U.S. tax court. You don't want to provide it. I'll go to U.S. tax court and get it.
Okay, so when you do get the Q-SIP, the administrative process is forcing the court to give you the accounting.
Yes, forcing the court to admit that there's a bond and that we need to do the accounting for it. We need to cancel and discharge it. So this is a setup, okay? The administrative process is a setup for a willful criminal act of embezzlement and tax evasion, right? So you file the A, you file the C, you cancel and discharge it. Then you look at them and say, hey, all this stuff is sitting on your books. Why aren't you guys filing taxes? That's a 7201 violation, 18 U.S.C. 357, right? Aggravated.
All trusts are ordered, revoked, and revested. 26 U.S.C. 671 through 677. Secured party is the grantor, bailor. Bailor. Contract on bailment. Look at the thumbnail. See, this is actually what you are when you're born. You're the one that grants all the data elements. You're the one that gives all the data elements. The benefactor is the one that gives to the beneficiary. The individual's name and social security number identify the record. The record itself is the beneficiary record. So here he says bailor, owner, and beneficiary. So again, I would change that word to benefactor. Because he is not the beneficiary. He could be the beneficiary if he's referring to his mother's estate. But in regards to his own estate, he would be the benefactor. He is now giving to his own estate. When he acquires property, it goes to his estate.
Why aren't you guys filing taxes? That's a 7201 violation, 18 U.S.C. 357, right? Aggravated identity theft, tax evasion, all kinds of stuff. So I'm letting them know, here's what you guys are doing. Get off my records. What are you doing? Superseding the form that I signed and put into your agency. Where did you get your authority from? I revoked it from you with your own forms.
So what happens if I
send you a notice? I sent you your own forms. Get off my records.
So if you're in the middle of a court case, say like I had an administrative hearing, now I'm in a writ of mandamus, and I'm about to go into a demur hearing. Say I bring it up in the demur hearing.
Yeah, why are you arguing case law? The only issue is the accounting.
Bingo. Did you hear that? The only issue is accounting. So the only case law that you need to bring in for the accounting would be the IRS codes that they use for the accounting fraud. And that's for their support. They will support you with those case laws. You're only bringing in the error in the accounting. And you're calling it an error in the accounting because somebody erred in allowing a foreign person without any authority to enter that account. That's the error. Forgive them, for they know not what they do. If they continue to do it after you've already revoked their powers of attorney and now they know, particularly through their own forms, like this man said, now it's no longer an error. Now it's no longer misfeasance. It is malfeasance. Knowing intent. identity theft, misprision of felony, and so many others.
So what if I bring it up in the demur hearing?
You can.
Does your administrative process include coaching on that?
Coaching? Yeah, because like I did with the how to appear in court, that's what you're going to be doing. Once you ramp up all the documentation to the IRS side, the only thing left is the accounting.
Okay, is that in that quote you gave me for 3,000, or is that something different?
Yeah, that's part of it. Yeah, that's part of it.
What say I'm can pull everything?
So we already know that this guy's going to charge $3,000 to help you out. Okay, which is reasonable, I think. You pay a man for his hire. I think that's simple. Seems outrageous. But in the grand scheme of things, if you understand how much that estate is really worth, you would understand the ability to transact securities through a private banker with a private trust account by selling stock certificates. You know what birth certificates are? Stock certificates. Stock certificates showing an investment in a state corporate entity and revesting it through a private banker for, say, $250,000. Just like a mortgage, like he spoke earlier, they could tranche it and sell that securities in parts, or they can sell it as whole. So if I issue a $250,000 value for a birth certificate, and he's going to get $25,000 of it, 10%, pay him for their hire to sell that security, he's going to do just like they did in the mortgages. He's going to sell that security around a circuit. He's going to make that $25,000. He's going to collect that $25,000. And that security is still out there. That security doesn't get canceled now. It still floats out there. You get your $250,000 and you pay him his $25,000. He's made $50,000 on a $25,000 deal. You paid him for your part of buying the security from you, and then he gets paid his part for selling the security to others. He's playing a middleman, getting paid on both sides. Same with the mortgage. They play a middleman, getting paid on both sides. And somebody's dipping into the estate to do it. In this case, you're the one that's dipping into the estate as the beneficiary, allowing him to do it with proper authority and powers of assignment. Understand how it works, folks.
What's the expected result?
It depends on how.
I wouldn't recommend doing that until you have your private law set up, though.
Far the court wants to push it and how arrogant they are.
Okay.
If they're being completely arrogant, right? We take them to U.S. tax court.
Okay.
This is what they're afraid of, because when you revoke and revest and they don't liquidate and handle the accounting and they don't do the equitable subrogation, they're screwed. They're going to prison.
Okay.
Because you're going to document this in U.S. tax court, all the violations that they did.
Okay.
The tax court is your friend if you learn how to use them. They are not the bad guy. They only establish the system. The system, or the the administrators excuse me. The administrators are the ones that are abusing the administrative process.
There's no arguing. So just like they say you can't argue the statute or code violations that you committed against them, do you think they can argue the statute and code violations they did against the IRS? No, because the case law is against them. There's nothing in their favor that says they can do it.
Okay.
It's the same thing. You're tipping the scales back onto them.
Okay.
Okay. So if they created a 1099-A, you think they're going to go into the IRS and say we didn't do it?
I don't know.
You're guilty. You did it. Here's the Q-Sid. Holy shit!
And that's the importance of the 3949A that I filed. Simply attesting that somewhere on the record, it seems to me that there's fraud being committed. And they filed a protection order because they said, I accused the prosecuting attorney of committing fraud when there was no such statement. I just said that it seemed to me that there was fraud on the case. So she turned around and filed a protection order saying that I accused her of fraud. No, I'm just saying I see fraud. I don't know exactly who's committing it because it seems like a bunch of you working together to do it. So I'm not going to name names, but I am going to name the record.
The 506T form. Let's pull the 1099A from the IRS. I've got copies of ones that people have got back from the IRS. It takes forever to get it, unless you got people on the inside. But yeah, they can't say they didn't do it. Here's a copy of it. Oh shit, you filled it out wrong. You made me the borrower and you the lender? That's tax preparation fraud.
And let me pull up Form A0430 because this is actually fraud upon the court. Okay, let's take a look at Form A0430. Let me make it a little bigger for you. And I want you to pay attention. This is right on the top of the form that you can fill out. Oops, a little too large. And right there it says administrative, since we're talking about the administrative courts, Office of the United States Courts, case information, date, time, operator, phone number, tape numbers, counter digits from to, da, da, da. You put your case number here. You put the presiding judge here. You put the district here. You put the location here. Type of proceeding. Equity. Subrogation. Over here it says official's title. And it gives district judge, bankruptcy judge, magistrate judge, or other. We're going to check other and put down chancellor. For a type of proceeding in equity subrogation, jury, no. Plaintiff, debtor, other, specify. Trustee, defendant, creditor, or other. Creditor. Do you see how the plaintiff is classified in like kind as government and debtor, and the defendant is classified in like kind as creditor? Are you paying attention? I'm going to take another quick break. Please enjoy. We'll be right back.
Hold up, grab my soda, cause I told you I'm colder than hell. I ain't buying what you sell, it don't ring my bell. Unless it's got the smell, you know, like grape pape. We ain't talking vapes or the color of drapes, or a gorilla in a cape. It's the good shit, just one hit. You so lit, you fall into a bit, non-bit. What's fucking funny is you're a monkey, a high school flunky, hero and junkie, obliteration of the carnation with gross castration, skewed citations by your intimations. Get real, young man, there's only one stand. You can't stand a suntan. How you gonna live on the land? Obliteration of the carnation with gross castration in skewed citations by your intimations. I'm a truth in rotation. You're a cheap imitation. Dark said hums, 808s make the ground shake. Cold as the grave, every word's a land quake. You're a flicker in a cipher, I'm the flame that won't fade. Step into the night where the shadows are made. What's fucking funny is you're a monkey, a high school flunky, hero and junkie. I'm gonna click another hit of this good shit, and I'm already it, so take over, it's been non-bid.
Thank you for joining us at Personality Inventory Mockumentary Productions.
Mhm.
So basically,
Uh-oh.
Todd, what you're doing is, it sounds like, is everything in the movie is the background of like the story and what happened and how how they commercialized everything, right? Because
Yeah.
you said they commercialized all these
They do
instruments.
everything- Yeah, they do everything backwards. They make
Right.
you the borrower and then the lender. That's
But
fine.
you-
Even under
you
Title
don't
12 of
need
the
a
Federal
hearing.
Reserve, they say that you're the lender. They're the borrower. Federal Reserve says so. I'm going to go with what the Federal Reserve says all day.
Do you need a hearing to enforce this, like an upcoming
Yes,
hearing?
you do need a hearing to enforce it. You have to go in there with your documentation in advance, right? And then you have to go in and force the equitable subrogation by discharge.
So
And if
you
they
have
don't
to
do it,
have a
if they don't-
scheduled
If they
hearing.
don't do it, you're going to U.S. tax courts, and you don't even have to ask. You don't have to remove the case. You're automatically filing key tam the next day. You're charged.
Key tam. Let's look it up, folks, so you understand what it is. Key tam. Q-U-I-T-A-M. Key tam is a provision of the False Claims Act that allows private citizens called whistleblowers. That's that form 211 from the IRS that he was talking about earlier, or what's called in legal terms that we like to use a lot, relators, because we, like the benefactor, give to the beneficiary. It is the relator that gives to the relative, and the person is relative to the living soul directly and no one else. To sue on behalf of the government for fraud against the government. Title 50 of the U.S. Code, Section 4309, Trading with the Enemy Act. Like I said before, oops, let me pull it up. Like I said before, 50 U.S.C. 4309b2. The name comes from a Latin phrase meaning who sues on behalf of the king as well as for himself. So let's look up 50 U.S. Code 4305b2. I said 4309, I meant 4305. And this is Title 50, National Security. 50 U.S. Code 4305, suspension of provisions relating to ally of enemy, regulation of transactions in foreign exchange of gold, silver, property transfers. 26 U.S. Code 1031, exchanges, real property exchanges for productive use or investment. Vested interests that are revested after they've been invested in fraud, enforcement and penalties. B2, any payment, conveyance, transfer, assignment, or delivery of property or interest therein made to or for the account of the United States or as otherwise directed, pursuant to this subdivision or any rule, regulation, instruction, or direction issued hereunder, shall to the extent thereof be a full acquittance and discharge for all purposes of the obligation of the person making the same. So if I'm the one making this directive in the interest of the United States and for the account of the United States, that would be a qui tam. In return for bringing the lawsuit and helping recover funds, in other words, you get those funds back. And of course, the United States receives a portion of those funds because it was done in their interest, using the laws of the United States as an administrator that took an oath to uphold the Constitution and the laws of the United States and the statutory laws of the states. The whistleblower can receive a portion of the government's recovery, typically between 15 and 30%. Now, that's the government's recovery on the vested interests that were invested. You get your interest back that you paid in already, the fines, fees, and penalties, plus you get a portion of what the United States gets back.
You have the evidence. It's in the court.
Okay, but what I'm asking is, I'm trying to figure out like the bullet I.
You have the evidence. It's in the court. You don't need to keep filing all these SOV-SIT documentations. Like I've been saying for years, they have the evidence. Go get it. Go to the clerk and tell them you want a full accounting of all of your criminal and civil cases. You need to get them for the accountant for tax records of a forensic audit. They better give them over. Otherwise, they themselves are now committing fraud as a clerk by denying the very person that will show up on the MoneyNet daily transaction log 120 as the creditor, and they are refusing to give creditor records to the creditor.
Want to discharge is I have a demur hearing coming up.
Yeah.
So I have two paths. See if he grants the writ or
Mark Basket, if you're still there, what do you mean, monkey? That was my roast of one Paul Unslaved, who claims to be the great white gorilla, the god of all media. That's my roast of him, because he ain't nothing but a monkey, a high school flunky, a heroin junkie. And it's so fucking funny. Back to the video.
to use the demur hearing to do this, because if he doesn't grant the writ, then he may give me another opportunity to amend.
Is your writ for equitable subrogation?
No.
Is your writ for equitable subrogation? Equitable subrogation. You guys understand? Equity subrogation. Why? Because the plaintiff is in fact the debtor and is in fact following the laws of the United States and the Constitution, supposedly as a trustee under an assignment. The defendant, however, is a living soul known as the creditor to that nation. Jeremiah 1:5. For all you Christians out there, before I formed thee in the belly, I knew thee. So before your mother knew you, that God knew you. And before thou camest forth from your mother's womb, before your mother discharged you of her waters, and you were no longer a resident in her, they made you a resident in the state. That's a false declaration. And on top of that, no one memorialized the event. And they allow the false declaration to continue. That is the rebuttable presumption that was spoken of earlier. It's a presumption, and it's rebutted with a proper memorialization.
Closure of all accounts?
No,
Or is it something else?
something else.
There you go. They're going to deny it. Now your writ can also, so your writ also has to include, if you're going after the bonds, you're going to have to give their violations. 7206 is a violation, isn't it? Fraud and false statements and concealment under the writ. This is right for appeal. This, and I'm not even appealing. I'm not going to open another. You can tell the judge, I'm not going to open another bond in the appellate court. I'm going to U.S. tax court. You just violated 7206, fraud and false statements and concealment. This language is so easy to read, right? The sixth grader can read this. You just concealed the accounting and securities.
Did you want to share something on the screen, Lisa? Go back to that.
Yeah, I think what I was trying to say is everybody needs to understand that not only your birth certificate or your social security, the FRAN number, these are all Q-SPIDs. We've traced 100% of them for our family. So this happens to be my birth certificate, and the number there is a Q-SPID number. And I think that it's very important for anybody listening to this that, you know, a lot of us identify with not only that birth certificate, but I really encourage you, and this is what Todd has taught me, which has been phenomenal, is go out to the statute. Todd always gives the statute. Go read them. When you read them, and it's like they're using colorful words in colorful admiralty, and you look at their definition of a person, you look at, you know, who owns those things. I mean, when you really start doing your homework here, and you go down this Alice in Wonderland, you know, event. I don't like the straw man either, but in every court case, and I have seen this and personally experienced it, where you'll notice your name in various forms. You know,
In my last case, and I've got it all right here, and I can still show it today, just like I've showed it before. 7 different styles that they used of the name in that court. But there's one particular document that I got from the clerk, that full financial accounting of both criminal and civil cases. And on one side, it always uses Keith or little comma Keith O. That's the United States side. The other side is the state side, where sometimes they use Keith Little, sometimes they use Keith O. Little. Interesting. In different styles.
your estate, your transmitting utility, which is just your middle initial. And if you're
So under 19 U.S. Code 81O, let's look that up. I'll show you that one. 81O. Share this tab instead. That's the one where we get the term resident. It says residents of a zone. Right? No person shall be allowed to reside within the zone. Zone is blue line highlighted, so let's look it up. It's going to give us a definition of what zone is. Zone means a foreign trade zone. So you're living in a foreign trade zone. If you're using that zip code, that is the zone, and it is a zoning improvement plan, not a law, not even a rule or a regulation. It's a plan. Except federal, state, or municipal officers or agents whose resident presence is deemed necessary, not voluntary, and not pre-categorically presumed by the board. The board means the board which is established to carry out the provisions of this chapter, the Customs Bureau. The board shall consist of the Secretary of Commerce, who shall be chairman and executive officer of the board, and the Secretary of the Treasury. Okay? Everybody still riding along with that? All commercial. That's 19.8 U.S. Code 81.0. Residents of zone. Let's look up the next one at 81N. Oh, goodness. They skipped to P. They left, or excuse me. I'm sorry, previous. My mistake. Let me have another hit. Previous. 81N, operation of zone as public utility. Operation of zone as public utility. So you are being used literally as a transmitting utility under the presumption that you are a resident in a foreign trade zone and you're operating as a utility. Therefore, you must be transmitting. What are you transmitting? What is mitting? Is that like mitigations? Think about it, folks. The language is clear once you comprehend the language. Once you educate yourself in the language, it becomes clear.
You're dealing in anything criminal, you'll just be John Doe. You know, like they're just going to do first name and last name. Every single one of these are corporate versions of yourself. And do you have to admit to who they are?
Corporate versions, which is a false conversion. It's a corporate version, which is a false conversion, and it is adverse. This is why it must be collapsed and revested with a private power of attorney through somebody that does have a securities license and access to a DTNL frame.
Or what they are. And we've done a really good job of trying to educate our children of, you know, knowing the difference. And through the equity subrogation, which we're talking about, if you are being asked on your, even what they're doing on the identity theft on the social.
How numbers are assigned application if you, and you is blue line highlighted, because under you means an individual down here. See my cursor? It's 20 CFR 422.402. You means an individual who owes a debt to the United States. Therefore, again, under 50 U.S.C. 4305B, to make sure you're not being considered an enemy in a foreign trade zone, under the Trading with Enemy Act and a foreign asset control system, you bring in the United States and their interest and account for them as a third person on their behalf. Key TAM. I've been saying this all along, folks.
Security, again, it doesn't belong to you. But can you further explain, Todd, even what it means on equitable subrogation? Because as you look at the fact that that is a trust and how you reclaim that, what that means to be a secured party creditor or holder due course, what it means when we look at how they're using colorable terms to assume that you're the debtor and automatically assign a contract that is beneficial to the United States.
Let's take a look at equitable subrogation. Okay, so what that's talking about is it's about securities, right? Because there's always a security somewhere with equitable subrogation. So that's the court bond. And what you're doing is you're throwing your estate under the bus. You're saying, I'm going to throw this thing into the mix here, your estate, your legal fiction, and that thing is going to replace me, and it is going to do the discharge. So they charged your estate, right, with the charge, the revised statute that you violated. So they charged you, and then your estate is responsible to discharge it. So while you're in the courtroom, they're assuming that you, as the living man or woman, is going to discharge, but you really can't. Only your legal fiction.
Yeah, you really can't. Right? Only legal fiction can. So when I, again, when I handed the birth certificate over in court that day, he had it in his possession. The one that entered the estate now had the equitable subrogation mechanism to do the discharge. That's why I got the discharge order. And it was a discharge. It wasn't, it's kind of ambiguous. It says discharge. So that to me seems like a reasonable, equitable discharge, equitable subrogation. And they wanted me to sign that release, releasing my personal services to do the discharge by issuing a bill for my stay in their nice motel. Sorry, I got a discharge order from the judge while I was there. Use that.
Fiction can discharge. So when you do equitable subrogation, that thing gets thrown under the bus to do the discharge, and you order it to do it. Right? Now, the interesting thing that comes into play is now the judge has to do the accounting, has to adjudicate and pay the creditors. Right? So the state basically is saying they haven't been paid. Well, yes, you guys got paid because everything's prepaid without recourse. Because
what? Yes, you guys got paid because everything's prepaid without recourse. How many times have I been telling you people it's prepaid? Go back and look at my videos. I even put a couple videos out there about it's prepaid. I'm not telling you guys anything new. It's known. You just refuse to believe it.
we don't have money. We have money of account, not money of exchange.
We have money of account, not money of exchange. 12 U.S. Code 1813. Share this tab instead. 12 U.S. Code 1813. Definitions. The term deposit means the unpaid balance of money or its equivalent. So if you get a bill for, say, your heating, if you get a bill for your heating and it's $89.13, what you have before you is an unpaid balance of money, and they're asking you to pay that money. They're not asking you to pay that equivalence. They want you to pay in money or a check. You know, a check or a money order is foreign currency. Look it up. Checks and money orders are foreign currency. In the meantime, this definition says the unpaid balance of money or its equivalent, which would be the bill, evidencing the unpaid balance of money, received or held by a bank or savings association in the usual course of business for which it has given or is obligated to give credit, either conditionally or unconditionally, to a commercial, checking, savings, time, or thrift account, or which is evidenced by its certificate of deposit. So if I have a private trust account with the bank for the estate, and I give them power of attorney to use that billing statement, which is a security, to access the account and extend credits from the estate to pay that bill, then did I not just use an equivalent of the unpaid balance of money known as credit? And did I not do that by a process of a deposit? That's 12 U.S.C. 1813 definitions, 12 CFR 204.2, oops, fumble fingers, definition section again. Deposit means the unpaid balance of money or its equivalent received or held by a depository institution. Not just a bank or a savings institution, but a depository institution in the usual course of business, which would be any vendor that accepts a deposit of monies of domestic or foreign origins. The money is the paper document. That's the money itself. The billing statement, that coupon that you rip off, that's the money itself. Okay? The whole page, that's a security. You tear out the bottom, hand it back to the utility company with the power of attorney to access the estate to receive credits. That's your payment. Same thing with the courts, except they're doing it behind your back because you don't know to do it first. Instead, you pay money in the form of Federal Reserve notes or a check or money order. Outside the United States, would that be foreign? Reserve. That's not a national currency. That's a reserve currency, foreign to the United States. And they have a contract to use it. The
bankruptcy. So the state has actually already been paid and they're lying to you and they are not doing their accounting. So it's a 7201 violation. They don't have a matching ledger. I've talked to plenty of clerks of the court.
That's the double entry ledgering that we're talking about. They don't have a matching ledger. Therefore, they're not following GAAP, generally accepted accounting practices.
Court and finance officers at the federal and state level, and they always tell you the same thing. We don't have any accounting. Well, how did you do the A if you didn't do the accounting? Did you not ledger a credit and a debit or an asset and a liability? Are you doing no accounting whatsoever? That's fraud. You're contracted with the IRS. You have an EIN number. You have a contract with them to do it.
You already have a contract. There's already a contract bond, bid, performance, and payment. And they're using a different kind of bond without contract as if though they're allowed to do that. No, that's shit they made up themselves. They're supposed to be following the bonding procedure set out by the IRS. Because that's who they have a contract with.
Right? And so they get scared really, really fast because they do have the accounting, but they're concealing it. And they
show the IRS anybody that is breaking their contract with them by issuing false bonds or not accepting the rightful equity subrogation, as I explained, sending that bill back with a power of attorney directive to access the estate for the credits, or assigning it through a banker, a private banker, that has an actual securities license to do all of it yourself, all of it himself. You just hand the entire bill to him and he'll do the coupon detachment and extending of the credits. It's not a loan and it's not money. It's the unpaid balance of money and it's equivalent. So he's sending them an equivalent of the unpaid balance of money, which is known as credit, by extending that credit from your estate that is already established.
Won't let you get to it without going through the IRS. So equitable subrogation is where they're supposed to do the accounting and do the discharge, set off, and what you want them to do is close the accounts, right? Close everything down. That means cancel and discharge, right? That's the A and the C. You do it for them, the A and the C, and then they freak out because now they're into willful failure to file.
Another important term in contract law, cancel versus termination. Cancel means it came to a closed end. Termination means there was detriment and suits might follow.
Return a 7203 violation. Okay. Now, when you're a secured party creditor and they're doing the equitable subrogation, anything that's left over, do they not have to give it to you? Oh, yeah, they do. Because
anything that's left over, do they not have to give it to you? Yes. So anything they make above and beyond their expected emoluments that ends up in that trust account is supposed to go back to you. So when you make claim on the monies that you've already paid in, as well as that money net daily transaction log 120 that shows you're the creditor, you should get everything you paid back and then some. Quit filing suits. Go to the IRS.
because you're first in line, because they don't have a UCC lien, but you're agreeing to take some of the money that they took to pay them for the alleged crime that you committed that has a commercial value to it. And what they're trying to do is during the equitable subrogation, they want to pay the state and pay everybody that's supposed to get paid, the sheriff, the prosecutor, but then they want to keep the rest of it. Well, if you're already a secured party creditor, they got to pay you first, right? That leaves them with nothing. They made no money on this entire transaction, none whatsoever.
And that's the security of placing that UCC1 lien on all of your property as the first party secured that says nobody else can come at it until you get your part. So technically, not only do you get your payments back and then the interest that you receive on that, they're not supposed to get anything until you get your part back first. See how that works? Bid bond, performance bond, payment bond. Payment bond pays secured party first.
Now, you could also argue that I'm a secured party creditor. You stepped in front of me. How did you do that?
So that seems like that's the remedy.
Everything.
The equitable subrogation is the remedy.
Equitable subrogation is the remedy because that allows us to step beyond the statutes and codes and policies and procedures into the equity realm, right? And handle the accounting, because now we're just saying you guys have created a big giant mess. There's no way to really unravel what you've done. So go ahead and zero out this bill and dismiss the case with prejudice. And now I'll just go handle it at the IRS. I got the A and the C. I just need the accounting from you, and then I'll file the B. But you got to give me the real accounting. And since you don't want to give it to me, I'm filing fraud with the IRS because you won't give me the real accounting. And the IRS, guess what? They have the terminals, so you can file the B and ask for a check back, right? And then the court gets stuck with having to pay the IRS back because the court's going to get a copy of the B, aren't they? Showing that they had to pay you. So instead of the court paying you, the court's going to pay the IRS back.
Lisa,
So
did you have a question?
I think you had this.
See, the IRS is your friend. Like it says, and like he said, they will pay you first. And then they will go to the courts and make them pay them. Those courts have a contract with them, and they have to fulfill that contract by the contract, not equity, but by the contract where there's a bid bond, performance bond, and payment bond. If they refuse to perform that contract, the courts stay because it's a corporate entity with a corporate entity, and they will remove the people and put them in prison. One is civil the other's criminal. They will remain with the civility of the contract and replace the people administrating it.
Scenario with Q, right, where the court tried to give him like a $40-something thousand check as an ovation. He said,
And what happened, Lisa? You want to tell the story with Q?
I would be happy to. So, Gavin, I know that you have taught very much so to try to do a CMA, with them. But when my son was wrongfully arrested, and we could have gone Title 42, we could have gone a lot of routes. But what I did is we just pulled the Q-SPIDs on the case. We canceled them. We actually did a FOIA request, actually 3 separate FOIA requests. One was to the Risk Management Department of the state, because they have to approve anybody that is bringing a case against someone. And then the second thing, and I apologize, my dogs are going to bark in 10 seconds.
And CMA is civil. What is it? It's a civil appeal. Let me pull it up here. CMA, legal meaning, civil miscellaneous appeal. It's a civil miscellaneous appeal, CMA.
Hold on a second. Thank you.
scenario with Q, right, where the court tried to give him like a $40-something thousand check as an ovation. He said,
And what happened, Lisa? You want to tell the story with Q?
I would be happy to. So, Gavin, I know that you have taught very much so to try to do a CMA, with them. But when my son was wrongfully arrested, and we could have gone Title 42, we could have gone a lot of routes. But what I did is we just pulled the Q-SPIDs on the case. We canceled them. We actually did a FOIA request, actually 3 separate FOIA requests. One was to the Risk Management Department of the state, because they have to approve anybody that is bringing a case against someone. And then the second thing.
And notice she said risk management. They are the ones that hold the bonds. Your city's risk management, county's risk management, state risk management, United States risk management, Postal Service risk management, insurance corporate company risk management, Social Security risk management. It's all insurance. And like I've been saying, it's prepaid. But don't believe me. Don't believe the neighbor. Don't believe the government. Don't believe your mother, for crying out loud. Do your research so you know. And like I said, I've done videos on prepaid insurance, taxes. It's all prepaid. And if you go do your research, you'll find that's exactly what I'm saying, because that's what they said. I'm only repeating what they said. This guy, these people, they're only repeating what's already said. What is done is what ought be done.
And I apologize, my dogs are going to bark in 10 seconds. Hold on a second. Thank you guys. Sorry, my son just came into the door. So as part of that, what we ended up doing is we traced the Q-SPIDs on the case and we FOIA'd them to the Risk Management Department. Then we also FOIA request to the in Oregon, all of the CRIS securities are created in a central location. And we found that out because of our FOIA request. We asked the clerk of the court for their EIN number, and they gave us an EIN number. But when we asked risk management for who filed the securities, the EIN number they gave us was also, and the name was the department. It's State of Oregon Judicial Department of Business and Fiscal Services. So this is what Todd was talking about, is that they have plausible deniability. So the clerks of the court and the judges are not doing the securities any longer. So typically the state or a comptroller or a business of fiscal services are doing it. Or if it is a federal case, there is a central group that does that. So once we FOIA'd them, we also FOIA'd them for the 1099A. We filed the IRS forms for the 1099As, and the court.
And that's basically allowing us to understand that principle of forgive them for they know not what they do. So if they take it out of the judge's hand, they take it out of the prosecutor's hands, they take it out of the clerk's hands, and they centralize it in one place in the state, they're absolutely correct. FOIA that one place. Forgive the others. Just give them notice. Hey, I need you to do this. I need these records from my accountant for a tax case, for subrogation, whatever. However you need to explain it. Let them know that they're accountable as a public servant in a public trust. And they have an obligation to give you those records because they belong to you. Without your existence, those records would have never been created. Before I formed thee in the belly, I knew thee.
Courts will definitely gaslight you, and that is what we have found. So then what we did is a UCC filing on the accounting, not against the judges, not against any administrators or anything.
Let me stop you right there, Lisa.
On the accounting, on the record is what she's saying. Not on the people, just the record. So it's like a subpoena. You're not subpoenaing the person. You're subpoenaing his testimony as it reflects a record. So the subpoena is technically only for a record, because when you subpoena a man, he can merely write down his words and create that record, or he can bring forth another record and say, that's all I got to say. The record speaks for itself. So let's see what David has to say.
Everybody that's on this call, do not ever lien a corporation or a person without a court order. That is a felony. You lien your.
So when you're listening to these gurus, understand it's a very important lesson. I know in my early days, I was in a study group and there were a lot of people wanting to do this. And they were gung-ho, and I had to get out of there because I knew what they were doing wasn't going to work. I didn't know all the mechanics of it, but I understand it much more clearly now. And like the man said, what they were doing was illegal. They weren't doing it in the proper process. They weren't doing it with intent to be fraudulent or illegal. And that's the problem. See, when these bad actors do this stuff behind the doors, behind the walls, black hat actors, things like this, as he described them, without having the proper license, that's the fraud. These people didn't understand the law well enough to know that you have to have somebody that is licensed to issue such securities, which is what a lien is. It's a security, making you a secured party. You have to have the proper bonding, period, plain and simple. It's all about the bonds. A man is bound by his word, right? Let me see here. A man is bound by his word. Oh, my computer is getting so slow. A man is bound by his words. Let's do this one. Seriously, people.
If a man is bound by his words, then why do they believe the words of others? If a man is bound by his words, then why do they believe the words of others? If a man is bound by his words, then why do they believe the words of others?
Property, and you list the people that stole your property in the collateral section, as these are the perpetrators that did this. You put them on public blast. You're not leaning them, you're naming them as the people that created this problem.
Yeah, so we
And that's why it's important to understand that 3949A that I filed. And then the prosecutor filed a protection order saying that I claimed she was committing fraud when I never said any such thing. Language is important. So when they lie on the record and issue protection orders because their feces are hurt, and they make false accusations that I claimed that she was committing fraud, the record itself shows that. So I don't need to worry about a protection order. Matter of fact, I enjoyed it because the scared bitch turned around and filed it another 4 years in a row. making it 5 years in a row. The court held a protection order to keep me out of the courts because I was onto their financial fraud.
When you fill out a UCC, there's debtors and creditors. So the agency itself can be named, but not the individuals, because these guys can charge you with a crime. So we did do a UCC on it. And then when they refused to provide us the accounting, we did a 1099-C and canceled the security. Now, for my son's case, what did they do? They doubled down. They said, I am not giving you a CMA. I'm not giving you remedy. And as part of that process, the first thing that happened is he did get a $40,000 check, and we sent it back. And we said, we're not accepting contract. We're not accepting any new terms of novation. And then he got a second check, and we don't even know, because it doesn't match any of the accounting. Neither of these matched any of the accounting. So then he got a $290 check, and we sent it back too, saying, we don't even know what this is for. Like, we're not accepting any novation. We basically filed for the accounting. Give us the accounting. But they will send a check. And at the moment you cash that check, and we've had this happen, then they're done because you accept.
And so what they're trying to do with that novation, understand the term novation, it literally means something new. A novel idea. It's a new idea, right? Novation. So literally what they're doing is they're wanting to hide that account and create a new account. And they do that through a novation by sending you a check for $40,000 as the initiation of a new account. It's all accounting fraud. And they know what they're doing. So these people are absolutely right. You don't accept the novation. You follow with the equitable subrogation as remedy. Otherwise, they're not following equity, and they're not helping with the creation of the remedy. They're actually participating in conspiratorial fraud because it's more than one of them. They're all acting behind the scenes doing it.
Accepted the term of novation.
Yeah. So term of novation is also sometimes called an accord and satisfaction, UCC 3-311, where new terms and conditions have been settled by the parties and there's nobody's guilty. Everybody's off the hook.
UCC 3-304, I think, as well. Let me look it up. No, let's 3-419. Instruments signed for accommodation. Okay. Accommodation is literally just a different term for creditor. Okay. If an instrument is issued for value given for the benefit of a party to the instrument, the accommodated party, and another party to the instrument, the accommodation party, signs the instrument for the purpose of incurring liability on the instrument without being a direct beneficiary of the value given for the instrument is signed by the accommodation party for accommodation. And that means the accommodated party, which is the beneficiary, who does receive the benefit of having the debt paid for him through an extension of credit. That's what you're incurring for the purpose of incurring liability on the instrument without being a direct beneficiary of the value. So let's look at UCC 3-402. Signature by representative. Remember that Social Security card? Okay. Every time you give out that Social Security number, You are the authorized representative giving a signature. And if a person acting or purporting to act as a representative signs an instrument by signing either the name of the represented person or the name of the signer, which in your case happens to be the same, the represented person is bound by the signature to the same extent the represented person would be bound if the signature were on a simple contract. So what it's saying is those instruments are contracts. If the represented person is bound, the signature of the representative is the authorized signature of the represented person. Okay? They're the same. So it must be the representative of the person represented. And the represented person is liable on the instrument, whether or not identified in the instrument. If a representative signs the name of the representative to an instrument and the signature is an authorized signature of the represented person, the following rules apply. If the form of the signature shows unambiguously that the signature is made on behalf of the represented person who is identified in the instrument, the representative is not liable on the instrument. Folks, if the person named in the instrument is Keith Little, and you sign unambiguously, as you've signed all your life, Keith Little, it is unambiguous. You must be the authorized representative. Because another representative through a power of attorney, such as a private banker named Tom Sawyer, would say, signed by authorized representative, Tom Sawyer, trustee. He's showing his represented authority and taking on the liability because it's not unambiguous. There is something that needs to be clarified, and that is whether he truly has a securities license and has a power of attorney to broker the deal. Learn the language, understand the accounting, and where the authority comes from. It doesn't come from them. The nation gets its credit from the people.
Family is number one, we've gone through the process and done secure party creditor, holder to course, and a complex trust. We operate in the private. Like, you have to learn to operate in the private. If somebody's trying to bring you into the public and they're filing these things against you, the thing that you can learn from this movie, as well as Todd and those that are doing this correctly, is this group in particular, and I know this is going to be made public, but this group can learn how to take control of those things, because they're committing crimes against you every time.
And that's why the best thing ever is last week when one of our clients was in U.S. tax court with a $450,000 tax bill under the discovery request in U.S. tax court. We listed the Q-SIPs and we revoked and revested and listed all the crimes that they had committed under the Internal Revenue Service. And the judge and the prosecutor for the Department of Tax, the Internal Revenue Service, they did not appear in court and case was dismissed.
Did not appear in court and the case was dismissed. See, they will run and hide. Isn't that what your Christian scriptures say? That when you boldly speak the truth, they will flee? That's your accountability. It is learn the truth and speak it. If you think you're speaking it now by handing everything over to public educators and your government and all these agencies that say they have authority, then you don't know what's going on and you're going to keep being abused. It's an abusive process.
And so this was actually being led by a gentleman, I won't say his name, but it's been led by a gentleman who's been beating the IRS for 35 years and has discharged more than $500 million in tax cases in 35 years. He said he's never seen anything like this. He said, I absolutely blew them out of the water. He says he's never seen in 35 years the judge and the prosecutor not appear in court. He says you always have to fight him for a little bit. He's like, this is the first time we hit him right out the gate and it's done.
Right out the gate, and it's done. Over with. Like I said, when I hit him with the 3949A in that case, they wanted to put me in fear and put a protection order out on me as if though I was a bad guy. They needed to be protected from me. Just like he said earlier in this video, you can surround me with as many people and as many guns as you want. You cannot instill that kind of fear in me. I don't give a fuck.
So anybody want to jump in and ask any questions or comments? Now would be a good time to open up. I know there were some in the
Yeah, I have one.
there. Who's that?
Catherine.
Catherine, yeah, go ahead.
So when you say by accepting the check, it's accord and satisfaction, does that get Q.'s, would that have gotten Q.'s case dismissed?
No, because they still made him go through the process, but he was doing the administrative remedy on the side, and they were trying to settle the filing of the Q.S.P.I.D. So there was 3 things that happened on his Q.S.P.I.D.s also, is they changed the charge, and the charge created a new, the change of charge created a new Q.S.P.I.D. And
so when they changed the charge, they were trying to deflect from it by creating a new one, a novation. They already created a new account by changing the charges. So it created a new case. Case means charge. Charge means case. They're the same thing.
then they changed the judges, and it created a new Q.S.P.I.D. So you have to be very cognizant of it. So he refused the checks and sent them back, and he demanded the accounting. And then
they changed judges in my case 5 times. Like I said, with the name, they changed styles 7 times.
entered into now doing the second step of actually the accounting fraud. So
So they're essentially still leaning your estate, your minor account. They're not dismissing the charge. They're giving you some money.
Yeah, so here's what happens. If you file the 1099A and C and you cancel and discharge the securities, the court never files the A and the C on their side. They think they're an exempt organization. They don't have to file. That's false. That's false. When they get the A and the C, they have to cancel and discharge and let the broker know to cancel the securities. Right now, they don't do that. So even if they dismiss your case with prejudice, they're still selling your securities. Right.
Like I said earlier, they never stopped selling those securities. 93 cases. All those securities, they're still revolving out there in the circulation system. Never ending. Always extending what? Because it's not money, credit. It's all based on a debt, an unpaid balance of money or its equivalent. Ask yourself, what is the equivalent? If I go down to the bar and I create what they call a tab, is it not an unpaid balance of money for which the bartender is giving you credit that you will come in and pay later?
So if you have revoked and revested and they're still selling your securities, you are owed all the interest, profit, proceeds, rents, everything that's generated from that. Now you can go after them in U.S. tax court because you revoked and revested, and now they owe you all that money.
Will they pay all that money?
You'll get it in U.S. tax court, right? Because they'll have to settle with you there because they can't. The U.S. tax court, what can they not do in U.S. tax court? Not disclose the accounting.
Like I said, all these instruments, all these commercial transactions, every last one of them is a taxable event. And I don't care if it's the public record or your record. It must be exposed for its accuracy, its integrity. It must reflect accurately. And that is on the IRS and their integrity. And if you think they don't want to uphold their integrity and they're not going to come out at you when you're exposed, something's wrong. That's why I know that, just as this man said, there were black hat actors that prevented that 3949A form from going out to the IRS. Had they actually received it, there'd have been something done on that case.
Or there in U.S. tax court only deals with accounting. It cannot be like not disclosed. And if the agents in U.S. tax court don't want to disclose it, 1203B1 violation, we're going to get you fired. Your job at the IRS is to audit taxes, audit the books. If you don't want to do it, and we've reported a crime, in this case, a case that's been dismissed and they won't turn over the accounting and they're still selling the securities, my God, somebody's going to jail.
My God, somebody's going to jail. I would pose that everybody that is involved and knows that it's a felony and has not reported it, go to jail for identity theft, conspiracy, and misprision of felony at minimum.
Wow. Okay, looks like Sabrina Max has her hand up too. Did you want to chime in, Sabrina?
Yeah, I have a question. So I had an opportunity to go to U.S. tax court. I asked the judge and the clerk and the attorneys that they would, sign an affidavit saying that it would be fair hearing and, innocent until proven guilty, all the good stuff. They did not want to. They said, you pay $60 or you can't come to court. I chose not to pay the $60. And then I found out later that the attorney on the other side filed false paperwork, false signatures. And I went back to the tax court and said, hey, this is happening. I'll pay the $60. I want to get this, on the record. And also, I didn't know about the their portal, the Dawson portal that they were using, because I was never instructed to go there to check documentation. Make a long story short, the judge declined my request for a rehearing and to reopen the case. And so I'm wondering, are there any effective remedies that could be applied so that I can get back
What do you think is going to happen when you send a motion order to revoke and revest and you've got the Q-SIP and the A and the C filed in a lien?
Well, I guess.
Understand that, folks, that UCC, that lien with the 1099A and C, because they didn't file it and they're required to. See, this is the issue I had with PayPal. See, they were trying to say that that money that was going into my PayPal account was income. Remember we talked about that earlier? Now, if that's income, then you're supposed to send me, a 1099K. Where's my 1099K? Are you not doing your job one way or another? Because that 1099K would prove that we have an income contract where the money going into that account is in fact registered in a specific income account and not a private Keith Orland Little FBU trust account where people donate through friends and family. Where's my 1099K? That's their failure. That shows they're the ones under financial regulations, FinCEN, are not following the financial regulations they're required to. Same with the judges. They don't have a broker's license. Therefore, they can't be selling the securities. Therefore, they can't make the claim on those securities as abandoned or cancel them. That's why the unambiguous authorized representative signature is so important. You can. It's unambiguous. You're making a claim on the abandoned property listed under Keith Little as the authorized representative in the same name, Keith Little.
I guess that's the remedy then, right? That's what I've got to do.
Yeah.
Okay.
So the Q-SPID tracing is about between $100 and $200, depending on who you can get to pull the Q-SPID. You have to then, again, Todd, talk a little bit about the A and the C. And
the A and the C, so the A has to be corrected first, okay? The problem with the Q-SIPs is we can get the major pool, but they're never going to give us the minor pool because it's under the Bank Secrecy Act. So you never know the exact accounting. And the exact accounting changes on a regular basis as profit interest is reported to the IRS. So that's why you'll never really get the individual dollar amount. It's up to the IRS to audit. So the A is to basically correct their filing, because remember, what did they do? They made you the borrower and then the lender. So you have to correct it. You have to make yourself as the lender and then the borrower responsible to repay the debt, and you have to audit, right?
And again, that's that form AO430 that I showed you earlier. Equity jurisdiction is equity, and it's a subrogation to amend the district court's administrative record, claiming that I was the borrower when in fact I'm the lender, according to the daily money net transaction log 120. Or what is it? Money net daily transaction log 120. It will show that I am in fact the creditor, just like the form AO430 in that court document says plaintiff is either the debtor or a government entity or other. The debtor is either the creditor or other. So the debtor is already known as the creditor. What is done is what ought to be done. There is nothing new under the sun. Both the money net daily transaction log 120 will show that, and that form AO430 together in a claim to the U.S. Supreme Court for equitable subrogation and House of Representatives and Senate for a private law establishing protection of the Keith Orland Little Estate Trust. A revestment of the revocable trust established at birth.
2201 code is for audit. So that triggers the audit with the IRS. And then once the IRS accepts the A, then you file a C and you cancel and discharge with the exact same information. And now here's the rub.
So I just got to play along here. I just got to play along. Because some people just don't get it. They just don't get it, folks. See, it's not about scary looks. See, if you think my face is scary, then you're not scared of the government raping you every fucking day, you pathetic bitch ass slave.
Is they're not going to get audited unless you force the audit with a bunch of different documentation through CID. Because the court does not think that they are required to file the tax records. They think they're exempt government organizations, so they never file the A and the C to trigger the audit. Right. This is why you're ramping up the documentation on your side to go back in through CID, through the front door channels, and then come after them. And
that, folks, is how you hold them accountable. That's your accountability. You have to learn what's going on so you can do what this man is saying. And yes, you can hire attorneys as counsel. You don't have to hire them as representation. You can't hire them as representation unless you have a corporate entity that they can then represent. So it would be a power of attorney to assign them in a revestment of that corporate entity through a private revocable trust, as the man explained. Again, his Lincoln profile is there. Go check him out. $3,000, probably get your whole family fixed up.
basically filed a key time criminal complaint against the tax court judge, the clerk, and the prosecutor in the case. So you're going to come back around after them in their own court. You can watch what happens. They're not going to show up. The case is going to be dismissed, vacated.
So you said, Todd, to Sabrina, that if she were to revoke and revest, what do you think is going to happen? What would happen in that case?
They're never going to show up in court. They're embezzling because you're using the revoke and revest codes for the trust, for the securities in the IRS court, and they're not allowed to not reveal the accounting. That would be a violation of Sarbanes-Oxley and Securities and Exchange Act and 7206. So that's why I showed you that list is what the IRS uses against people doing this.
And so it wouldn't only pose the identity theft and stuff like that, but these people in these positions of public service, which is a public trust, it then goes to treason and sedition. Every living soul that they bring into those courts through threats, duress, and coercion, that's kidnapping. For all you Christians, Deuteronomy 24:7 says, anyone caught stealing one of the children of the brethren of Israel and making merchandise out of them, That's the Article 1 corporate courts, where they're initiating these bonds for commercial investments. That's why they're talking about revesting. Shall be put to death. Ye shall put evil away from amongst you. They're the ones that are supposed to be going to prison.
Yes. Right, that list of 33 items, that's the basic core list that every single court and bank violates every single day. That one.
And something that is important is we tried
Every single day. Embezzlement. Every time they issue those bonds, embezzlement.
on Q's case, my son's case, we tried to subpoena the fiscal services and the comptroller, Elizabeth Stein, who is here in Oregon. And immediately the state attorney did a motion to quash. They don't want to appear in court. They absolutely do not. They will do anything and everything to avoid appearing in court.
Can they quash accounting in a tax court?
No.
No.
That's the only place they can't do it.
So what do you suppose happens when I bring back that child support record? Let alone all the fines, fees, and penalties I pay for all those 93 cases, of which I quit paying years before I had my last case. I just quit going to court, signing UCC 1-308, and then just never showed up in court. And somehow, despite the fact that they're not allowed to go forth unless they have a defendant in court, they still adjudicated the cases and claimed that I owe them these monies. Because they're the ones that drew off the account and issued the bond on credits to begin with. They're all evidence of fraud. Every last one of them. Been saying this for years.
Tax court. I don't know anything about tax court. Sabrina, you've been to tax court before. You said you didn't. How did it go for you?
Well, I was told that they didn't have any jurisdiction because I wouldn't pay their $60 until I got,
Pay the
something
$60 and pull the Q-SIP and go after them.
That's what I'm going to do now, because
Yeah.
I did try to give them their $60 again. They said, no, this case is done, but I'm going to do that. I'm going to use your remedy.
Yeah, this case is done because the court novated it and created a new case. You're still filing on the original case. File on all of them. All of them.
The case isn't done. The Q-SIP is open. They can say it's done all day long, but that Q-SIP is open. It hasn't been canceled and discharged. The case is still active.
So, Todd, back to the beginning.
And the evidence in my case, I've got that full accounting of all the civil and criminal cases. Every last one of them. Every last one of them. Summary judgment. Never a final judgment or even a declaratory judgment. Every last one of them, a summary judgment.
Beginning here, you figured this out because of your dad was the court was broke, I guess, back in the day in the 80s, right? They were broke. And then Ronald Reagan had passed a new law or a new commission of some kind to have the court get money from bonds. Is that how this all started?
Yeah, that started because they were broke and they needed money. So it's just as the government always does. When they run out of money, they find a new way to tax us.
I see. So they started doing this and they started, making money on these securities from the taxes. And now basically the strategy is, okay,
if I'm putting everyone to sleep, I should do it more often because I've got 20 viewers now. I had 24 earlier. Usually I've only got 5. So maybe I should put people to sleep a little more often.
Be doing that. Will you please show me all the accounting, please? I want to get the records so I can find out what's going on.
Yep. And then
they don't want to.
And they avoid the Brady rule. So if you try to use the Brady rule against them for exculpatory evidence, they say, well, we don't have what you're asking for, so we can't comply with Brady. Brady doesn't apply. Oh, well, in U.S.
Oh, imagine that. Imagine that. And all these corruption, it's not corruption, it's criminal when they say they don't have the records, but they do. See? Just like in these previous videos I've been pointing out, they're always trying to hide the record. That's not corruption, that's criminal. They do it in all cases, systemically across the board.
Tax court, we got this Q-SIP right here. We filed all these A's and C's and liens. Guess what? I liened my property. It will be coming out in U.S. tax court. You will not be able to avoid and not disclose the accounting. Somebody has it. And since you guys don't know who has it or claim you don't know, guess who has the terminals that can get it? Oh, that would be the IRS. And
the IRS. Absolutely. So if those cases all have evidence of commercial transactions that under normal circumstances would be taxable, and when they send me a dismissal, my last case, the 94th one, I got a dismissal, and they sent me a notice that the charges were dismissed and all costs are taxed to the defendant. So what they're doing, again, is taxing the defendant, which is the record. And there's no record of an UCC, 1099A or C, showing the taxable event. Well, they say they don't have record. And this is the same case where they said there were zero finances and they found no bond. They found no long title. There were no charges. And yet they turned around and issued a bond, noticing a taxable event that wasn't reported to the IRS.
Securities and Exchange Commission, because under Sarbanes-Oxley and Securities and Exchange Act, if they don't have it either, everybody's committing fraud. Sarbanes-Oxley got put in place by Congress because the government was lying about the accounting.
This is all starting to come out now. It looks like with this movie, and now people are learning about you, and you're really one of the leading, maybe the leading expert on this issue. It sounds like, and so you do a lot of consulting, and is that how it normally goes for you?
Yeah.
Or what?
Yeah, I mean, the main thing that I do is this is what I was brought to the INC conference, where I met Sarah and everybody else at the conference, is to tell people that you need to have everything in complex irrevocable trust to protect your assets, because the government's doing everything in their power to tax you and take your property. I was very fortunate enough about 4 or 5 months ago, I was brought in by Merrill Lynch to a very high-end business meeting.
It's interesting. Yeah, dog. I mean, shite. I can't see now. I'm blind too. Why don't you just man up and say shit? Are you such a coward to censorship that you have no idea of how to speak the truth? Shite is not what you're supposed to be using here. It's shit. Man up, you bitch ass slave.
For high net worth clients, minimum 10 million. And they wanted me to kind of like audit the little couple-day conference that they did. And I told them at the end of the conference, a couple days later when we met privately, that I was actually very proud of their attorneys that were there and their CPAs that they brought in for their clients. Because the one thing they expressed to all of them is, if you don't have an irrevocable trust, you will not be our clients. We cannot protect you. The government is here to take everything from you. That's
the revestment of the trust. It's already established as an irrevocable trust. So you have to revest it. You have to collapse that one and create one yourself. In the irrevocable trust, you have other trusts. Okay, it's like a hereditary trust. It doesn't step outside of the family. And in that, you have revocable trusts, which are the lifetime trusts of the inheritors and the estates. That's the collection of private property known as building your assets, building your fortune. Not handing it over to a corporate entity that will steal it from you if you don't.
Conference to all of their high net worth clients, where they were basically moving their equity position in their corporations as the owners to the irrevocable trust. right? And then throwing everything in the irrevocable trust. Now, the attorneys can only do grant or irrevocable, so they can't split legal and equitable title because that violates their statutory codes. They can't do the complex, and that's what we talked about at the private meeting afterwards. And they're not comfortable in the complex irrevocable trust side because they don't understand the accounting rules. The CPAs generally got the concept of that it's a pass-through entity, but they weren't familiar with doing
Pass-through entity. So let's talk about the credence. The credence of the word. In the beginning was the word was God, and the word was God. That's where all credence comes from. And that's the credibility of your word. That's where credit is extended. Good faith and fair dealings. This is a faithful saying that that thou constantly affirm, that he who believed in God be careful to maintain good works. These are good and profitable unto men. That's equity. Coming with clean hands, making sure that it's clean from the beginning.
accounting for it and didn't really want to go down that path of going back to the IRS for the complex training. And then, so that's what we were talking about, the protection using complex irrevocable trust and then hitting everything through the accounting side.
Wow. Well, any last comments or questions from anybody before I wrap up here with Todd? We want to thank you for coming on. Anybody else have their hand up? Okay, Lisa, yeah, go ahead, Lisa.
Thank you for watching. Please share it as well. And I'm going to tell everybody again, and I will reiterate it many times in the future as I have many times in the past. Do not believe me. Do not believe the neighbor. Do not believe the government. Do not believe your mother, for crying out loud. Do not believe these people. Do not believe the guy in chat saying modify the SF 30, 14, 14, 14, 16, 14, 18. I have no idea what he's talking about there, but do your research so you know. That's what I'll be doing with this one. I'm gonna check out what he's talking about. I'm gonna see if they're valid or not. See if they have anything that might be helpful to me in my situation. But either way, stop believing. Know. And know enough that you can discern right from wrong, good from bad, truth from lie, so that you can always put forth that clean hand right from the beginning.
Go ahead. Sorry. I was just going to ask Todd, can I contact you for a private consult?
Let's wait till we get off the recording before we go to that, and we'll do that too.
Sure. Okay, great. Thanks.
Yeah, go ahead, Sue Frost.
Hi, Todd. I just wanted to ask on the complex irrevocable trust, are you speaking of a private or a public entity?
Oh, no, they're private only.
Private only.
Private only. So don't
Absolutely. This is imperative to understand. Again, they established an irrevocable trust. That's a private trust. That's the estate trust. It is not a state trust. It is not a public trust. They only have legal title to help administrate it while the beneficiary is still a minor and can't make competent commercial decisions himself. Once you turn 18, you're supposed to collapse that and create your own irrevocable private trust to remain in control. If you don't, that legal title that exists in the state gives them legal control and entry. You still maintain the equitable possession and use title, but they will use it against you in an imperfect usufruct.
use that with, I've had a number of people have me audit their trusts. They're calling them complex, what do they call them? Complex, irrevocable, discretionary spendthrift trust. And I just have to shake my head. No, that's not what these are. Those are actually identified as the IRS by sham, as a sham trust because they're not set up properly and they are set up to do tax evasion. So these follow.
So again, understand, don't listen to gurus. Don't believe me. Don't believe the neighbor. Don't believe the government, for crying out loud. Don't believe your mother. Do your research so you know. When you're competent to know and can prove you're of sound mind and body, they can't make accusations like that against you. That's why I don't do all this bullshit these gurus are telling me to do.
The IRS rules for subchapter J to operate as a pass-through for accounting, splitting legal and equitable title properly. The IRS does approve these if they're written a very specific way, and they put them in file with your trust. So when you come at them and you're filing your taxes with them, or you're reporting your returns, they do recognize that and they do accept it operating this way.
What was
Not
it, Sham?
any type of tax evasion. We are doing standard accounting, which is identified as a pass-through, which is tax avoidance, because you're doing your accounting, right?
You have an EIN number to, so
Yes.
your bank account with the EIN. And
Absolutely correct. Again, learn the language. It is not tax evasion. That is illegal. It is tax avoidance, because there are certain exceptions and exemptions that provide that you don't need to pay taxes, particularly when it's stated it's voluntary.
not
Yes,
this.
the IRS will issue an EIN number with the third digit, which is a 6 or a 7, which lets the IRS know that it's a complex trust and they expect you to do pass-through accounting. They expect you to 1099 every transaction, right? Remember what the IRS is. They are an administrative agency under Title V collecting information. They don't have it unless you assess it and give it to them. As the complex trust, they like us because you're telling them where all the money is going so they can catch tax evaders. What do you think every world
Another deflection of projection in total confession, confessing that he's blind and deaf, but somehow deflecting that by projecting that it's me that made him so. Good job. I love this stuff. See, a man's intellect is limited and biased by his vocabulary, folks.
government is trying to do right now with the electronic banking? They're trying to catch terrorists and tax evaders. Here you go. I'm a trust. What do you want? I'll give it to you. I'm happy to give it to you. Thank you very much for giving me tax credits in return.
There are
Tax credits in return. What are all those deposits that you made through your employment checks? Those are credits. You can get all those back too.
Offset our tax liabilities.
they're a collection organization, really, right?
Yeah, they're collecting information, and you assess your own taxes. They have no authority to assess any data that you give them unless you commit fraud and give them the wrong numbers. Right? If you intentionally give them the wrong numbers, that's criminal. If you make a mistake, it's civil. Right? So when you're on the trust side, you're saying, I'm just the trustee.
Basically, the IRS.
It's a mistake. I don't know anything about accounting or taxes, so I just put down 0. I didn't go through an accountant. I used a simple form and I put down 0 because I don't know. I believe that's what I owe, 0. If you can prove otherwise, please feel free.
That we have from the bank, and there's what we're going to report.
So the IRS is our friend, is what you're
They
saying.
are our friend.
Yeah.
On the trust side, they are our friend. On the 1040 side and the corporate side, they hate you because they know you're concealing information from them. They hate you.
They know you're concealing information from them when you're using those 1040s instead of a 1041. See, they know there's something wrong with that record. Don't you? That's what I've been screaming for 10 years. The record is in error. I'm not a corporate entity.
I see. But as a trust protector, they're your friend.
Well, I hope before it's over, you tell us where we can go to learn more. I'm excited, inspired. Thank you.
Good.
Lisa,
that's everybody's point. Lisa's point, my point, Sarah's point with the birthright is just understand that, yeah, we're kind of trapped in this matrix thing, but if you understand the difference between public and private, you give them what they're asking for with the accounting, they're very, very happy with you because you're actually helping them balance the books at the IRS. That is the core problem. The books at the IRS are a train wreck. So the people that are reporting fraud to the IRS with all these bonds and 1099As and all the people doing the stupid stuff like filing 1099As, trying to tap the minor account, they're pissing the IRS off because the books are all unbalanced and there's fraudulent entries everywhere. Literally, the department that fixes the 1099As is 3 years backed up.
And just like this AI system, like I've been saying, It's uniform throughout all jurisdictions. If you put shit in, you're going to get shit back. I hope you enjoy the taste.
3-year backup to fix anything. So we're very, very fortunate that we have people that work very closely with the IRS Criminal Investigation Division, both externally and internally, where we can kind of jump to the front of the line, right? We don't have to wait 3 years. And that's 3 years to our initial response where they say denied, right? Stupid. Now we're opening it.
Did you have anything to add, Chris? Do you want to?
Let's see. One of the few things that I'm concerned with what has not been spoken about, and that would happen to be the private to public mix here. I know that Todd had said that we need to stand on the private. Yes, I absolutely, totally agree. Everything I've built is based off the private, but shouldn't there be some kind of like a disclosure that yes, there may be this miner's account there, and what is my relationship to that miner's account to keep you in the private rather than to enter into the public?
Yeah, that's actually the estate conversion process that we do. It's very, very complicated. Lisa can attest to you that it's not a fun process. But let me hold on. I was going to put this in the comments too. So this is a.
Yes, John. John Harnick says, Brother Keith also said the post office is our de jure government. He's way ahead of the most. Understand, people, they have their own rules of procedure in the contract appeals court. And everything, like I said, under that Constitution is contract or trust. So when we're dealing with these administrative courts, like I said, they have a contract with the IRS. And they're placating that you are the transmitting utility, the representative agent or officer of a federal, state, or municipal government, which you are not. That is the error. Point that out, and that's all you need to go by. The accounting is error because of the wrong capacity applied, a pre-categorical misidentification, allowing for all of these identity thefts. I never gave any such authority. Nunc pro tunc.
A general memorandum for what the estate conversion is and what needs.
The Postal Service is in fact known as the contract authority of the world. Understand, the Universal Postal Union is a labor union by contract. And if you have a fidelity bond with the Postal Service, which indemnifies them for any misapplied terms, capacities, or contract infringements, they will rectify it by following those contracts. They hold all of those contracts. There must be a postal authority somewhere in order for anyone to post data elements to an account.
To be done to stay private. And you have to understand that even when you do an estate conversion and everything's done properly, because the government presumes that 99.9% of the people operating as a minor and a debtor in the system, they don't go and look before they take action and start filing tax records for you and creating bonds. And so this is a protection mechanism. It's not an attack vehicle where basically you can walk in and say, who are you? From where did you get your legal title authority to manage my estate? You're not the trustee. You're not the beneficiary. You are not a secured party. Who are you? Where is your contract? I don't see one anywhere. I've revoked and revested legal and equitable title. Powers of attorney have been revoked. Agency agreements have been revoked. Power of trustee has been revoked. Who are you? Where's the contract? Show it. Show your accounting. Right?
So,
This shuts them down very, very fast. If you got anybody that's even
Some of those documents I filed on the day of sentencing when I handed in the birth certificate in my last trial, revocation of a power of attorney and durable power of attorney notification. Ain't no man my authority. None. I've never given any of you people any authority. And if you want a competency test, let's go.
remotely competent in the space of the trust and understanding what you just said to them, that they should run. And believe me, I've been surrounded by marshals, I've been surrounded by sheriffs, and I asked them these basic questions. I asked them the Sixth Amendment.
And so when there's 94 cases on the record, multiple ones that you've never walked into court on, never paid any fines, fees, penalties, and the last one where you actually ended up with a sentence of 60 days, walked out refusing to sign any documents, despite the accusation that you still owed all these fines, fees, penalties, the hotel stay, a DNA sample, and a drug eval, and never looked back without giving them anything, and they still haven't issued a warrant for anything, despite the fact that you've not only openly asked it in court, but in city council and of the mayor and of the city's councilor. Why are there no warrants? Am I special? No. They just know their balls are caught in a trap.
Nature of their accusation, where their surety bond was at. I've literally been screaming at them to get back here. Give me your name and your badge number. They literally run.
So we don't answer any questions, but we ask questions.
Yes.
There's a very big difference.
Always to any.
Is that not the way Jesus posed everything in your Christian scriptures? He didn't make accusations. He asked questions. When they claimed to Pontius that this man is the Christ, he is the Messiah, and Pontius asked him if he was the Messiah, he says, if that's what you say. And he didn't want to say that, so he released him back to the people that were making the accusation.
Anybody that's in the criminal enforcement realm, what's the Sixth Amendment nature of your accusation right now? And where's your surety bond? You're operating under color of law. Who are you? I've yet to run into a single sheriff, even the sheriff.
So when it was the people making the accusation that he was making a false claim of being the Messiah, they strung him up. And that's not their place to make a judgment. Isaiah 54:17. No weapon formed against thee shall prosper, and every tongue that rises up against thee in judgment thou shalt condemn. Because they're false judgments. There's only one judgment that comes, and that's the day you meet your maker. That's what you Christians believe. But yet you spend every day flinging false accusations at each other without even knowing it.
Here that's in charge. Ask them the question. You know, at the Masons Lodge, you know, they've got the main guys in charge of the Masons here. What's the Sixth Amendment nature of any criminal action? I don't know. Well, you've been a sheriff and you've been in internal investigations. You've been in that realm. You have advanced degrees in criminal justice. And you said you've never read the Sixth Amendment to the Constitution?
Oops. Oops. See, when I spent that 47 days in jail that last time, they gave me 60. I got 13 days good time, and the judge handed me a discharge order. But in those 47 days, I had two items with me. King James Version Bible and the Constitution. And it was amazing because I can iterate the Constitution like many cannot, particularly these people that are supposed to know it and have never read it. Pathetic.
He's like, I've never heard this before. It's like, well, you better learn real fast because that's your job to protect both sides because you took an oath to protect that Constitution and you refuse to acknowledge the nature of your accusation because you're incompetent. You are a legally incompetent minor. This is why you don't know the answer to this question.
So Todd,
Electronic Code of Federal Regulations. Title 5. Administrative personnel. Office of Personnel Management. And this is why I was saying I refused to sign that release paperwork upon discharge. because it would have been releasing my personnel management services. Subchapter B, civil service regulations. Recruitment, relocation, and retention incentives. We spoke yesterday about retention fee in accordance to an officer that got fired or got demoted and put on desk duty and relapsed and was caught doing meth, not just once, but repeatedly. And they paid him a retention fee. Supervisory differentials and extended assignment incentives. And it says competencies. So let's talk about competence. Like I said, bring it. Means the knowledge, skills, abilities, behaviors, and other characteristics like equitable demeanor, good faith and fair dealing, and not ignorance of any kind. An individual needs to perform the duties of a position. Federal government means this is your de jure government, folks. Means all entities of the government of the United States, which is a corporate entity. So federal government means all entities of the government of the United States, and that's those United States citizens and residents by enumeration at birth that is then assigned a social security number, including, which means it excludes all else under statutory interpretation principles, the United States Postal Service and the Postal Regulatory Commission. The Postal Regulatory Commission, not a post office or post service, but a postal service and postal regulation having to do with things posted to any account in the name of the United States or the interest of the United States or on account of the United States.
Talking about what is the Sixth Amendment nature of it. So if you have common law, you have equity, and you have culpable admiralty. Okay.
Yeah.
And
Yeah.
if you also look at the jurisdiction of it, so if there's no injured party in any of these statutes that they create, they actually are void because they.
And this is where a big movement is coming in through these notices from I can't remember her first name, Jennifer Saxton, I believe. And other people in her group are going from state to state, hitting all the counties and giving the board commissions of the counties notice, along with affidavits about these judges putting people in jail for civil infractions which are not criminal by calling them criminal, a violation of federal rules of civil procedure 2. There is one form of action, civil. They must address things civilly. That's Jessica Saxton, correct. Thank you. Thank you, Jessica Saxton. So, it's being well known that that kind of stuff is going to stop. That's kidnapping, folks. Got to stop. You're not supposed to be converting civil statute interpretations as retaliatory threats and intimidations by false imprisonment, kidnapping, and things like that. That's debtor's prison. That's putting people in prison for commercial transactions that they may or may not know anything about, which would be mistakes on their part. But again, not mere corruption on those that are supposed to know. Competent. So yeah, bring your competency test. Let's see who's really competent, because I'll test the competency of the doctor right in front of him. How's your competency to determine my competency between me and the judge? I'm going to check yours first.
They violate CFRs and they violate the original Constitution. So when we look at the nature of it and we ask very specific questions of who was injured, what jurisdiction you're bringing this into, there is actually two questions.
You know, it's funny, Lollipop B. Again, a man's intellect is limited and biased by his own vocabulary. Because I found that in my humility and my humbleness, that when I reached the top of a peak in my travels and I looked around all across the world, all across the mountaintops and down into all the valleys, and I realized one thing: no matter where I'm at, I'm exactly where I'm supposed to be. Even if it's on my knees in the deepest, darkest shadows of a valley of death, or on the highest mountaintop of glory of grace that he provides, so I can better see and better hear. It's too bad people like yourself want to conflate that the Christian principles laid out in those scriptures are false, because you don't see them as principles. You see them as some kind of fairy tale of whether Jesus was real or not. See, I'm not a Christian. I'm not Hindu either. I'm not Muslim. I'm not Buddhist. But I do know the one main principle throughout all of those, and everyone I've ever known. Do unto others as you would have them do unto yourself. So you want the negative aspect of life. That's probably what you get. Me, even on my knees, I receive the glory. Maybe read Job and enjoy your job, you bitch-ass slave, acting as Hitler's willing executioner by slinging a sword of words with a dull edge.
Let's go through both questions so they understand that. One is the Sixth Amendment nature, and then what is the jurisdiction?
Yes, the jurisdiction under Article 3, Section 2. What law form jurisdiction is this?
Article 3, not Article 1. Article 3, in all criminal prosecutions, Article 3.
Case being charged under. This is clearly an administrative court. Is it common law, equity, colorable vice? And you have to say colorable vice admiralty so that gets their attention really fast that you know the answer to the question. So something that my dad was very, very specific about is don't ask any questions in the courtroom you don't already know.
By admiralty, this is 18 U.S.C. 7. Special maritime territorial jurisdiction. Relative to 18 U.S.C. 8. Obligations and other securities of the United States relative to 18 U.S.C. 9. Vessels of the United States. United States citizens in dual citizenship under the 14th Amendment as state residents.
The answer to. So it's colorable vice admiralty because here's the 1099A, right? Remember, that's why I showed you the A and C form, right? You have a Q-sit. And so if it's not a common law court because it's not an Article 3 court, it's administrative. That means there has.
The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made. And treaties made, right? You suppose it's the Universal Postal Union involved in all the world treaties under the United Parliamentary Union, or the, International Parliamentary Union, that created the Constitution for the United States to form a more perfect union, labor union. arising under this Constitution, the laws of the United States and treaties, in law and equity. Okay? Share this tab instead. Judicial officer. So, when we see the judicial power shall extend to all cases in law and equity, and then we see the judicial officer department is a neutral, independent forum within the United States Postal Service. The de jure government, consisting of the judicial officer, the Office of Administrative Law Judges, and the Postal Service Board of Contract Appeals. And we see their judges, Chairman Judge Alan R. Caramella, Administrative Judge Board Member Judge Catherine Crowe. So it's creating a board of representatives. Administrative Judge Board Member Judge Diane M. Migo, Administrative Judge Board Member Judge Richard Rowe. The Postal Service Board of Contract Appeals has jurisdiction to consider and decide any appeal from a decision of a contracting officer of the United States Postal Service or the Postal Regulatory Commission relative to a contract made by either. Federal government means all entities of the government of the United States, including those transmitting utilities known as residents, when they use a residential address through the Postal Service. Sample documents, mediation agreement, not arbitration as in administrative courts and contracts, mediation agreement. Postal Service Board of Contract Appeals decisions right here, and rules of practice. Folks, you will see they follow a different set of rules of practice. I urge you to check this stuff out. People, do not believe me. Do not believe the neighbor. Do not believe the government. For crying out loud, do not believe your mother. Do your research so you know. This takes that competency of knowledge, skills, and everything else that they're required to have. This is what's going to be able to replace them eventually. This is what you need to teach your children so they don't become indoctrinated into that black world of shadows. Show them the light by learning the light of the truth yourself. Those administrative courts operate under specific contract for corporations. This here exposes the contracts that they already have and that you're a third party in a trust known as the benefactor, foreign to their domestic private club. You ain't in it, but you're the creditor. You're the benefactor. You're the grantor. You're the one that provides the trust, the trustor, the irrevocable trust that assigns a different person as a trustee. Language is specific, folks. So let's go back to the video. The judicial power shall extend to all cases in law and equity. And that judicial power lies in the judicial officer department, which is a neutral and independent forum within the United States Postal Service and Postal Regulatory Commission. That is the judicial branch.
Has to be a bond somewhere. I need to see your writ of attachment bond, your writ of attachment of body bond. I need to see the bid performance and payment bond, right? As soon as you start going after the bonds, they get really.
As the money changers of the world, the Postal Service is the one that has the main contract with the Internal Revenue Service. The president of every nation, the leader of every nation, goes forth every so often in what's known as a postal congress with their relative gross domestic product and pay a percentage of that, a tax, to the IMF, known as tax credits, that are dependent upon the credit of the people and their labor that is being converted to Medicare qualified government employees. A false conversion, a bearing of false witness. The record is in error. Fix it. That's all that needs to be done.
Nervous really fast because you're just like, Your Honor, I'm very well versed that bonds all have to be held in trust. So that's a trust. So I'm going to revoke and revest that right now so we can do equitable subrogation. And if you think you're going to get around that, I'm going to see you in U.S. tax court for embezzlement. And I'm going to charge you as a named defendant because under the 7th Amendment and ex parte Young, you do not have sovereign immunity or judicial or absolute immunity for embezzlement and tax evasion. Nobody does. Right? Make sure you guys think about the argument with the, yeah. So here's the nice thing with your IRS issue, Sabrina, is
that's right. Nobody does. Because like I said, if you're the one signing unambiguously in the exact same name as the person named in the instrument, and therefore are not liable for the person named in the instrument, and you're being forced to take upon that liability, then there must be an equal exchange for the unpaid balance of money or its equivalents, the credit. That's all we have available today, folks. The thing you think is money is not actually money by default. It is money by particulars. Federal Reserve notes called money. It's not money. It's a promissory note, each and every one of them.
Did that judge have an SF-61 on file to not strike against the Constitution and the laws of the United States? And if you revoke and revest under Title 26 and he's an administrative judge in a Title 26 court and he doesn't do the accounting and you revoke and revest, you think he's going to show up in that courtroom?
Nope.
Nope. Because you can literally look at the U.S. Marshal and you say, you are now my witness. The judge I revoked and revested. The judge just embezzled from me. Arrest him. You are an arresting authority.
So here's the link to the movie. Everybody could check it out. And it's going to be at birthrightthemovie.com.
Lollipop B. This is just for thee.
The panelverse is full of scarlet letter ladies of the night. They embroider their tragedy like a price tag, begging the world to stare. They mistake their degradation for fame, dancing in the spotlight of their own misery. I don't have to force them to the street, and I just charge them rent for the stage. I am simply the broker, collecting a tax on their tears.
You're nothing but a bitch-ass slave. Try some more, though. Try some more.
We'll go into much more of a background and more of a story on there on all this stuff. And Todd is, going to be on the super highly advanced level. I mean, he's the one that's doing all the consulting and the strategy over these people. So it may be a little bit advanced for a lot of people that are seeing this for the first time, but there's actual enforcement. And I think one of the big takeaways I could learn from Todd today is like, there's a big difference between a notice and enforcement. And for years, it's always been.
Yes, but don't dismiss the notice. They're not saying that the notice is not needed. It is required. But with that notice must come the equitable subrogation. That's the key. That's what opens the accounting. Okay, and that's what you're supposed to go for, the record, not the judge. Let them hold them accountable for that if that's what they find, like they did in the Enron case.
Notice, you know, even the land patent stuff and all that. Yeah, notice, cool, but it's not an enforcement mechanism, you know?
Yeah, land patents are interesting because you do an administrative notice of affidavit of negative averment when they don't file for you. So that sets them up for all the penalties they're committing. Then you do a writ of mandamus in U.S. tax court.
There you go.
And that negative averment is where you start placing all those charges. Okay, saying, well, no, not quite, because what they actually did was embezzled. They committed identity theft. I'm a whistleblower and I'm pointing out the record. You can hold them accountable. I just want my money back in the interest of the United States as a salvation project to recoup for them in their interest. What the fuck? You're the ones bowing down to God. I don't bow down to God. See, that's where you're mistaken. That's where you're mistaken. See, people that think they need to bow down to God have been misinterpreting things. I've always seen it that we're supposed to look up to God. So maybe you've been one of the ones that's indoctrinated and needs to be forgiven because you don't know. See, it's not about descending to your knees. It's about ascending, no matter where you're at, on the top of a mountain or in the deepest valley. It's always about ascending. See, that's the negative connotation that you keep inflecting in your intellect by your language. A man's intellect is limited and biased by his own vocabulary. So as you keep saying this, yet I'm the slave. Yeah, you're the slave because you're the one carrying the ID in your pocket saying daddy's your pimp and you're the whore. You're the scarlet letter whore. Don't you see? Oh, of course not. You're blind and deaf. So why am I even speaking to you? To point out the obvious? Maybe it's not so obvious to others that are in your same boat. But hopefully if I'm pointing it out about you, they'll look in the mirror and see themselves too. See, I too was once a bitch-ass slave. I was a fucking fool. I was the idiot. I was the victim. I don't play victim, though. That's a bad position to play from as you speak about bowing to one's God. See, that's from a position of victimhood, not praise.
So that's your enforcement.
That's your enforcement because they created a system that is so difficult and cumbersome to navigate that nobody knows what to do. So you go to the U.S. District Court and you just say, we just need an easy remedy here, which is file. Here's my paperwork, file. I don't need.
In admiralty, which brings up the walk on water. Because he brought it up in admiralty and asked questions of the record that you keep bowing down to. That's the hilarious part.
Ask for anything else. You guys have the ability to scan this and drop it into your systems. That's all I'm asking for.
All right. Well, okay. Well, we got two more questions up before we end. Go ahead, Sabrina Max.
Just quick question. So when the question is asked about, the authority and so forth, and they come back and say it's frivolous, then I've dotted all my I's, crossed all my T's, and I could show up with the revoke and redesc because they've just gaslighted me.
So now you know what we do with our team at the IRS Criminal Investigation Division. We ramp up all the documentation that you need to prove a willful criminal act has occurred of tax evasion and embezzlement. Now, once IRS CID opens.
And when you see 93 cases on there repeatedly doing the exact same thing, it becomes a pattern of practice. And that pattern of practice, as extensive as it gets like that, it shows that it's intentional. Repeat offense. 93 times in an Article 1. Posing as criminal. not 93, not all 93 were criminal, but those that were solicited as criminal, all fraud. And the others portraying that I was the minor and accessing the minor account without a securities license to do so, again, still fraud.
That, and we say, hey, one of your agents is involved, that's a 1203B1 violation, we can move to have him fired by the commissioner. They cannot say no to the accounting at the IRS, period. Not allowed.
Not allowed, because each and every last one of those documentations will lead to a place where you gave a name and social security number and birth date. Identifying dual citizen records. That's you. And that's why I keep saying you have to hold yourself accountable. When you realize that what's going on is wrong and you're participating in it, and there's a way to prove that it's wrong, and you had no idea, and now that you do, you can no longer continue that way, you won't sign those documents if you're a good man, because you know it would be a lie. You would have to correct the documentation first. Coming with clean hands, good faith, and fair dealings. You have to come with equity if you want equity.
I'm very inspired and excited, and I have a lot of this work done, so I can't wait to hear how to get more in touch with you, Todd. Thanks.
Yeah, just the process of paperwork. And remember, they're committing so much fraud. And this is sometimes, so, you know, the list that I showed everybody with those 30-something violations, sometimes I laugh and I tell them, I'm just like, dude, your list only needs to have like 5 things on there. They're already guilty. Why do you need 30? And they're just like, well, it could be about 200. And I'm just like, I know, you don't need 200. You need like 5.
Sue Frost.
Yeah. So, but that's a list for mortgage foreclosure fraud. That's the.
And see, that's the interesting thing about using that full acquittance and discharge in the interest of the United States on account of the United States, and for the person making the same for full acquittance and discharge, so no person shall be held liable in any court. That goes to your policies now, and now people have to go through educational training, or if there is an actual criminal thing, then they could provide penalty. It is a military tribunal, and they could provide penalty through a tribunal, which is not a court.
Standard list that the IRS uses when they
Muted, Sue.
the court for mortgage fraud.
Sorry. 2 questions. Number one is, there's something in the IRS code right at the beginning that said nothing here is to be construed to be law. And so there are those who are out promoting that, you know, you don't have, it's a voluntary thing. You sign the 1040 to pay. So you're not talking,
sign a 1040. Yeah.
You're not talking about IRS code when you're talking about the felonies and the embezzlement and the fraud that's being committed.
Correct. Nude Guru says, should have done the due diligence in the first place when choosing to participate to know it's a scam or not. Ignorance is no excuse, a point crucial to remind. And I do remind people, why are you sending your children to public education and indoctrination centers? That's the problem. Mom and dad were indoctrinated just like their mom and dad, and therefore I too was indoctrinated. And this is the correlation of why you need to forgive them, for they know not what to do, and act in good faith and fair dealings at all times, and let there be full acquittance and discharge. And if any natural consequences come about, that would be natural upon their own incident, and not due to yourself requiring equitable subrogation and remedy. Okay. So when it comes to this education, it becomes a matter of autodidactism. This is the one talent that we're told to observe the world around us. And instead, we're indoctrinated to remember the world presented to us through a curriculum. Okay, it's a divisionary tactic to keep us from observing the natural world, which is what our mom and dad would naturally teach us if it weren't for a public indoctrination system that made it so comfort and convenient that they could send their kids off to somebody else to deal with that responsibility and teach them what they need to know in a classroom, a square box, instead of living daily life and teaching them reading, writing, and arithmetic as it applies naturally to many things, and also observing them in your own nature as parents to see where their talents embedded naturally are more expressed than others. Some are musically talented. Some are artistically talented. Some are mechanically talented. All kinds of things. And we don't allow those to flourish. We cut that spiritual nature off and send them to a box. Amazing shit. I get frustrated seeing so many of our younger generations walking out of high school with this diploma as if they're somehow diplomatic and don't know the language, feeling like they know enough, and never picking up another book, never learning another thing. It's amazing.
So what do I look at the IRS and I say, hey, you want to file that notice of lien? There's a Q-SIP behind that. I'm coming after you. That's equitable subrogation. I'm going to set off and discharge that thing. Then I'm coming after you for filling out my tax forms. How do you think we beat the IRS? Go ahead and file that lien. Find out what happens to you.
And I agree totally there. New Guru again says that indoctrination is accepted by choice would be the only thing that I'm not agreeable with, because we all know that our younger years are the most impressionable. And if we're indoctrinated as minors who can't be competent because they don't know yet, so therefore it's not by choice. To break that cycle, one must take full responsibility, however, for themselves, I agree with. Foregoing blame for responsibility, I agree with. And replace excuses with enthusiasm, I agree with. If there's anything more appropriate to express what I call passion, when you hear me get passionate, is my enthusiasm. I have enthusiasm. That is my praise to this, quote, God thing. I am enthusiastic about life. I am enthusiastic about truth. I am enthusiastic about love. I am enthusiastic about competence. I am enthusiastic about talents. I am enthusiastic about everything that is positive. Dedication versus addiction.
But it's true. We don't really have to pay taxes. We don't have to participate, but someone's participating in embezzling from us on.
Are they filling out tax records for you when they do a lien and they fill out a 1099-A? Where did they get their authorization to file tax records for you? Where are these records that you filled out for me?
And here you go. So dummies choose to participate in scams on YouTube. Yeah, break the cycle from one scam to the next. Prove that this is a scam. It's a non-monetized channel. I'm putting out information, and I'm specifically telling people not to believe me. Not to believe the government, not to believe the neighbor, not to believe the mother, for crying out loud, to do your own research. So if you're one of the dummies that choose to participate on scams, it's only because you're not doing your own research, not because I'm up here doing a stream about it. Okay, let's make sure we get that clear. Right? See, that's not, again, that's one of those amazing how it works out, because again, it's the intellect showing your bias, that dummies choose to participate in scams on YouTube. That's your own deflection in projection of your own confession that that's what you do. Otherwise, you wouldn't be so sore about it. You'd be sore about the government that scams you. But you're not sore about that. That's what proves you're the bitch-ass slave. You proudly carry that ID in your pocket while professing people like myself that don't have IDs, don't have bank accounts. For crying out loud, I don't even have an irrevocable trust. I just have the knowledge of how it works. Simple. Bitch-ass slave.
Okay, got it.
So people inside the IRS that will readily admit that the IRS is a joke, that the whole thing's a sham.
Okay, and then on the allodial title, are you saying it's not necessary to go through that exercise? I mean, it's
some counties will easily let you file a allodial title. Like for example, here in Hawaii, they actually have revised statutes for filing a land patent. They let you do it here easily, even on the statutory side. California is a different story. You have to take them writ of mandamus every single time. And believe me, I have all 310 Supreme Court and federal cases that California violates every single time. The Supreme Court won't even hear land patent violation cases out of California anymore because they've repeatedly told them they're breaking the law. They're operating under color of law by blocking your filings, right? So, but what California does is they're testing you, right? Oh, no, you're not allowed to file that. Fine, affidavit of negative affirmation. You have 10 days to file. If you don't, here's your writ of mandamus. Here's all the violations you just committed. Here's our ledger of the penalties. You can either pay the penalties, which is going to be like $5+ million, or you can file. It's your choice.
Or if you take control of your estate through a private trust, does that manage the land?
So you have to understand. You have to understand land patents. You can't, for land patent, you cannot have a lien on your property from a bank. That's basic land patent act knowledge. So if there's a lien, you cannot split legal and equitable title and put it into a complex trust. Once you own it, you split legal and equitable title. Now you're under law instead of statutory, right? So you put it back under the protections of law, federal law, right? So now the state is taken out of the loop. But there's a number of different tricks.
They're not taken out. They're not taken out. You have to go through all this to get title.
Yes, because the file. If you don't, here's your writ of mandamus. Here's all the violations you just committed. Here's our ledger of the penalties.
But through a private trust, does that manage the land?
So you have to understand. You have to understand land patents. You can't, for land patent, you cannot have a lien on your property from a bank. That's basic land patent act knowledge.
But through a private trust, does that manage the land?
So you have to understand. You have to understand land patents. You can't, for land patent, you cannot have a lien on your property from a bank. That's basic land patent act knowledge. So if there's a lien, you cannot split legal and equitable title and put it into a complex trust. Once you own it, you split legal and equitable title. Now you're under law instead of statutory, right? So you put it back under the protections of law. You have to understand. You have to understand land patents. You can't, for land patent, you cannot have a lien on your property from a bank. That's basic land patent act knowledge. So if there's a lien, you cannot split legal and equitable title and put it into a complex trust. Once you own it, you split legal and equitable title. Now you're under law instead of statutory, right? So you put it back under the protections of law, federal law, right? So now the state is taken out of the loop. But there's a number of different tricks.
They're not taken out.
And this is why it's important to go to the Senate and House of Representatives to make sure it is separated. So it is a federal protection under a private law. That evidences that is no longer under statutory code of any kind. It is a removal, not to federal law, but through federal law, showing you have substantive priority exceeding that of federal. It's private, not public.
They're not taken out. You have to go through all this to get title.
Yes, because the system got in the 50s got put into the statutory system. It got flipped. So now you have to unravel. Your point of doing the land patent is unravel all the colorable violations, right?
Good to do it.
Yes, and so I have talked to the Secretary of the Interior about this, and they do admit that places like California are absolutely batshit crazy, and they don't follow any laws. They just make shit up out of thin air, and it really irritates them that the.
You know what, Lollipop B, I'm glad to drop the link if you want to come up and discuss your knowledge. You seem to portray here, you all simple, all right? Like I said, decades behind. It shows how slow you go. By that, you're implying that you got this all figured out and you did it decades ago. So please feel free. Come on up. If you want me to drop the link, let me know. We'll discuss this. Otherwise, all your statements so far have proved limited bias. Sorry.
The state thinks that they supersede the Land Patent Act and the Homestead Act, right? That is written by Congress and is basically considered stare decisis as far as the Supreme Court is concerned. But the question, well known, they don't even want to hear it in the courts because this counties are just getting fraud and people are just bending over and accepting it.
Okay, question though, if there was, there was talk in 20.
You know what? All you need to do is stay out of trouble. Don't do criminal shit. See, that's the epitome of your bias. You don't understand. You're back in the blue until it happens to you because you're not understanding that they're operating in civil contracts and you have no contract with them. So anytime they bring forth a suit against you, whether it be civil or criminal, they are not being corrupt. They are the ones criminally acting against you. Speeding tickets? You have to be on state business, performing the functions of public office, and having surrendered that vehicle in agreement as security for that agreement in case you violate it by handing the title over to the state. And they give you a certificate of title proving that you are supposedly saying that you're going to use that vehicle now leased back to you. The yearly registration requirement is what they try, or licensing fee is what they say, but that's a registration fee for the motor vehicle theft prevention program. And you coincidentally sign all this documentation under that presumption, supposedly using that vehicle at least 50% of its use for trade or business, which is defined as the performance of the functions of public office. And you agree with that by stating that you're a resident of the state of Iowa and give them a resident address. And this is clearly evidenced on your driver's license with the individual's name and number that identify the record, that then also correlate and relative to the resident who uses that address as a principal place of business, leasing his personal services. See, you don't understand your idiocy. That's okay. You keep doing dumb shit and find out how they convert the civil actions because of that ID in your pocket and the use of all these instrumentalities without knowing, and they're going to call it criminal. And then let's see what happens to you. Who are you going to call? You going to call the police? You're going to call the judge? You're going to call some scam artist on YouTube? You're an idiot. Keep speaking, though.
2020 to 2022 that there was a bankruptcy, that the United States is already bankrupt and
Where is it?
conservatorship.
Where is it?
Pardon?
Where is it? Nobody's been able to provide it to me and I can't find it. Where is it? Has to be publicized. The last time I checked, they continue to register the corporation in Florida every single year. Go to record one.
Delaware.
Yeah, no, Florida. 10, this is record 10009. They register every year. Starts in Florida.
What if they just opened a new corporation?
Where is it? Show it to me.
Yeah, I can't track it down. I tried it.
That's all internet.
Lollipop B, lollipop B. Back to blue until it happens to you. What the fuck can you do to stop it all? Stop all of it. Sweet fuck all. Well, see, it only happens because good men do nothing about it. So if you do anything, again, don't believe me. Don't believe the neighbor. Don't believe the government. Don't believe your mother. Do your research so you know. How many times do I have to tell you? It's simple. Yet you're so lazy you won't even do that. That's the bitch. See, a man's intellect is limited and biased by his vocabulary, and it shows he's a lazy bitch-ass slave.
A lot of internet myths out there that people don't have any proof of. So
yeah, that's why I tell people, show me the corporate registration, because I still see them registering in all 50 states. It starts in Florida.
Should be pretty easy to find if they were bankrupt. You know, that would be easy to find.
If they are bankrupt and they have ownership of our property, then we're part of.
Yeah, show me the congressional records.
Yeah, I want to see the bankruptcy.
Show me the congressional records. It has to start there. They have to issue the orders from Congress to issue the bankruptcy. They can't just do it in private.
Right.
They're
Bankruptcies are public.
They're public.
Yeah, 100%. A lot of myths out there that people had not used to, but a lot of you. I heard that too many times. I don't know where it came from, but
yeah. So one of the things that we issued to the judge about the trust for the U.S. tax court is I pulled the congressional records from 1967 that said that the entire government is held in the S.W.A.P. trust and that the people are the co-trustees and co-beneficiaries. Right? We did Henry Boland's and a couple of other things that basically says everything's in a trust, and we're just like, oh, there's a trust. And it looks like, according to the federal government, we're the co-beneficiaries and co-trustees, so we're revoking and revesting this revocable trust. Why do you think that judge and the prosecutor didn't show up? Because I also told him to revoke and revest the birth certificate because we threw that in there with the Q-SIPs, and we revoked and revest the minor account with this unlimited credit. That's a trust.
Unlimited credit. Birth certificate. One birth certificate, unlimited credit. In case you guys aren't hearing this. And again, don't believe me. Don't believe the guy in the video. Do your research so you know. Ask the right questions of the right people, the IRS, the private bankers, the attorneys. This guy, ask him. He'll show you sources I'm not showing you. He'll explain things in a way that I'm not explaining them, or in a different way, different perspective, more accurate.
There's a custodian. There's a trust. Yeah, I want to revoke and revest unlimited credit. Please cut me a check for infinity. Where do you think they ran?
Yeah. So Todd, you said that Gene Keating, you saw him, he got a black card?
Yes, he probated his estate and revoked and revested it, and the Federal Reserve freaked out because he had the Q-SIPs for his brand number and his social security number, his birth certificate, everything. He had Q-SIPs for everything. Revoked and revested everything. You have to liquidate. They said you can't liquidate an unlimited account, but will you take this black card? And he said okay.
Yeah, take this card.
Okay, $200,000 a month was the limit.
Just spend less than 200,000, Gene.
Well, you could spend more than that, but you contracted to limit your spending to $200K a month.
Yeah, try to live frugally, okay?
Yeah, exactly. Yeah, don't wait.
200K a month. 200K a month. That's 2.4 million a year, folks. 2.4 million years, or 2.4 million a year. Like I said, birth certificate, $250,000 to the local bank. I'm going to live lightly. It's unlimited credit. And again, do your research so you know. The term deposit means the unpaid balance of money or its equivalent received or held by a bank or savings association in the usual course of business and for which it has given or is obligated to give credit. Equivalent. Credit is equivalent to the unpaid balance of money. If you guys don't understand English, I urge you to learn it, getting a concise English handbook and maybe even a tutor, and start looking up these definitions and read them for what they are. This system works on a credit.
How much candy can you buy?
Well, thank you, Todd. Thank you, everybody, for joining in. And with Todd, everybody, check out that movie. And let's do it. Hopefully, we can do it.
So, as I've explained, for those that don't know, I'm a cancer survivor. Little over 4 years ago, I was diagnosed with cancer through the local emergency room at Unity Point Hospital, known as Allen Hospital. And when they handed me a commodity, a piece of paper that said on it, sales agreement. There are two things I did. I read the back of it, giving the conditions of the sale agreement. And when I was done and I signed it by Keith Little, Benefactor. And in that sales agreement, and I can pull it out and read it again verbatim, but I've done it before on video, and I'll be glad to do it again, particularly in any court. Be glad to send a copy of it to anybody. but in simple terms, not quote verbatim, but in simple terms, it says that I agree to make payment, third-party payment, for costs of the equipment and services, so long as it's understood that credit is given to my account. So if you want me to make payment of the unpaid balance of money for this bill, I'm going to deposit this bill, which is evidence of the unpaid balance of money, which would be its equivalent. And on it, it has information, and it's going to get logged into a MoneyNet daily transaction, 120, as a security that's going to recognize me as the creditor. So if you haven't already given credit, then you're obligated to give credit under my directive. Understand your part. Learn how to pimp them. You are the pimp. You're not the whore.
A man's intellect is limited and biased by his own vocabulary. I walked into prison, still a boy of 120 pounds. When I walked out, I was healthy and mindful. Know thyself. Heal thyself. See, it's not just the physical, but the mental health too. You can get help before prison. Call 988 for help today and be blessed.
Hold up, grab my soda, cause I told you I'm colder than hell. I ain't buying what you sell, it don't ring my bell. Unless it's got the smell, you know, like grape pape. We ain't talking vapes or the color of drapes, or a gorilla in a cape. It's the good shit, just one hit. You so lit, you fall into a bit, non-bit. What's fucking funny is you're a monkey, a high school flunky, hero and junkie, obliteration of the carnation with gross castration, skewed citations by your intimation. Get real, young man, there's only one stand. You can't stand a suntan, how you gonna live on the land? Obliteration of the carnation with gross castration in skewed citations by your intimations. I'm a truth in rotation, you're a cheap imitation. Dog said hums, 808s make the ground shake. Cold as the grave, every word's a land quake. You're a flicker in a cipher, I'm the flame that won't fade. Step into the night where the shadows are made. What's fucking funny is you're a monkey, a high school flunky, hero and junkie. I'm gonna click another hit of this good shit, and I'm already it, so take over, it's been non-big.
Thank you for joining us at Personality Inventory Mockumentary Productions. The Panelverse is full of scarlet letter ladies of the night. They embroider their tragedy like a price tag, begging the world to stare. They mistake their degradation for fame, dancing in the spotlight of their own misery. I don't have to force them to the street, and I just charge them rent for the stage. I am simply the broker, collecting a tax on their tears.
I'm out, and you know me, folks. I love you, but I don't give a rat's ass whether you love me back. That's to say, I don't care if you hate me. I don't care if you don't respect me. That part's on you. So may God bless you and have a good night. We'll see everybody next time. Thanks again. Hit those buttons.